Okay, Chair, we're now live.
Thank you very much, Matthew. Lovely. So welcome everybody to this virtual licensing subcommittee meeting that's being conducted with members, officers and members of the public at various locations, communicating via audio, video and online. There is the opportunity for the public and the press to listen and view the proceedings. Before the meeting starts, I would like to invite the committee member and scrutiny officer to explain how proceedings will work and to confirm that members and officers are in attendance. So I'll pass over to Anna.
Thank you, Chair. Please note that the meeting is being streamed live onto YouTube and recorded via Zoom. I'll undertake a roll call to make sure everybody here can hear and be heard. When your name is called, please indicate your attendance to confirm the required members, officers and members of the public are present. So panel members, Chair, Councillor Elizabeth Dennis Harberg.
Yes.
Councillor Daniel Allen.
Here.
Councillor Gerald Morris.
Yes.
And Councillor Ian Albert.
Yes.
Thank you. Officers, Steve Cobb.
Yep.
Jasmine Jennings.
Yep.
Teresa Campion.
Yes.
Matthew Hepburn.
Yes.
And I'm Anna Gavea. And members of the public, we have Rob Scahill.
I'm here.
Thank you. Piers Warren.
Yes, I'm here. Thank you very much.
Thank you. Andy Turner.
Yes, I'm here. Thank you.
And Fred Miller.
Yes, I'm here.
Thank you. Maggie Miller.
Me too.
Thank you. Lee Garnish.
Yes, I'm here.
Chris Gorm. I think your microphone's muted, Mr. Gorm.
Is mine muted?
No, it's on ready.
Can you unmute your microphone? Do you want to try that? I can come back to you later. I can see that you're here, but I can't hear you at the moment. Mr. Paul Hooton.
Yes, I'm here.
Thank you. Chris Bentley. Don't think Mr. Bentley's here. Gwen French. Angela Camp.
Michael Camp is here.
Thank you.
My wife's sitting beside me.
Lovely, thank you. Don't know if we have Anthony Marison.
Yes, you have his son.
Thank you.
He's in the room, thanks.
Thank you. Can I just take your surname? Is it Marison also?
Same as, yeah, same as
Yes,
Andrew.
thank you. Brilliant, thank you. Jane O'Brien. Tony Whitby. Mr. Whitby, can you indicate that you can hear? I can see you're here, but I can't hear you or see you. And Liz Smith.
Yes, I'm here.
Thank you. And is there anybody else who I haven't called out who's here?
Phil and Kate Corney.
Oh, thank you. Phil and Kate Corney, thank you. And who was it who was having trouble with their microphone? Mr. Gom, can you try unmuting again, please? We can't hear you at all. Your microphone's on mute. I'll try and send you a message in the chat to try and help you with that. We'll move on. Extracts from the partly remote meetings protocol are included with the agenda, and the full version is available on the Council's website, which includes information regarding live streaming, noise interference, rules of debate, voting and Part 2 items. Members are requested to ensure that they are familiar with the protocol. The hearing preliminary is included with the agenda and details the arrangements for the hearing. Please ensure you've read this. Are there any questions before we start the meeting?
I think there's quite a few people who haven't had the Zoom link shared with them. We're just seeing a few people kind of message us now. They are on the agenda. I'm just wondering.
Could you send me, possibly in the chat for the meeting, some names and their names, please, and we can check if we've got their email addresses already.
Okay, will do. Thank you.
Brilliant. Thank you very much. Okay, I'll now hand over to the chair to continue the meeting. Thank you, Chair.
Lovely. Thank you very much, Anna. Okay, so again, just as a polite reminder to help the meeting go smoothly as possible, given that we're not all in council chambers at the moment and we're doing this online, if you are able, when you're not speaking and actively contributing, to press mute on whatever device it is. If it's a computer keyboard, hit the space bar or click on the little microphone in the bottom left-hand corner, or sort of fiddle around with the phone and iPad settings. That will help us immensely. And if I invite you to speak, or if you want to make a contribution, I will notice you. And if you struggle to sort of take yourself off mute, again, I've got a lot of patience and nowhere else to be today. So please don't feel rushed or under any pressure due to the oddness of having to deal with technology for this meeting. Lovely. So my scripted notes, going back to those, tell me that I need to run through the hearing procedure that's in the agenda pack. There was an error, I think, in the initial procedure that went out with these papers. So we've uploaded a fresh procedure today. So very briefly, what we're going to do in this hearing, which is a premises license review for the Orange Tree in Baldock, is run through an introduction of the various personalities that you're going to be seeing today. And then we'll sort of hear from the licensing officer and their report, and the people who have raised the objection to the license's premises and brought this application for review will have the opportunity to set out their case. And Mr. Scahill, as landlord at the Orange Tree and license holder, will then be able to respond to that. After we've heard all of the evidence and asked questions of everybody, we will then retire and we'll consider what the options are and whether the committee is likely to consider imposing, for example, some conditions on this particular licence to assist going forwards. So, introductions. Council sitting on the subcommittee today is myself, Councillor Elizabeth Dennis-Harburg. I'll be chairing, and I believe I'm going to be assisted by Councillor Daniel Allen. But Anna, is Councillor Albert or Councillor Morris my third member, and who's in reserve?
Councillor Albert is the reserve member, I believe. Excellent. Okie dokie. So in the event that one of the panel is unable to continue, for example, due to technology reasons, Councillor Albert will be able to step in and assist and ensure that the licensing subcommittee remains quorate and can continue to hear this review of the application. The legal advisor is Teresa Campion, and she'll offer and advise us on any points of law as and when they arise during proceedings. Our licensing officers are Anna, who's been assisting us ably thus far, and the licensing manager, Steve Cobb, is also present. And I think Jasmine is here. I can't see your last name, sorry, Jasmine, so I can't give you a full introduction. Okay, and then the main applicants that I've got listed on here are Mr. Miller, who I think who instigated the review, and then I've got a number of other members of the public who are quite coldly termed other persons. So that's everybody else who's contributed and written in response to this particular request to review. And then the premises license holder is Robert Scahill. So those are the people we're going to be hearing from. I can see Mrs. Miller has raised a hand, as has Mr. Warren. You both would come under other persons. I'm not actively taking submissions at this point in time, but I will hear from everybody who is on the agenda as something that in the sort of legal parlance is termed other persons.
Councillor, I actually represent the premises licence holder who's Green King, not Mr. Scahill. Mr. Scahill's the DPS. I just wanted to make sure everyone was aware of that.
Okay, and are you going to be representing today, or is Mr. Scahill going to be
So
representing?
I will be making submissions, and Mr. Scahill will read a short statement as part of those submissions.
Okay, so if I could just check with Mr. Scahill, are you happy for us to go to Piers before you when it comes down to your part?
Yes, absolutely.
Okay, no worries. Thank you very much for that. That's very helpful, both. Did you need to notify me of anything now, Mrs. Miller?
Yes, the Jane O'Brien, etc., was certainly due to come and be here with us today, but I'm just wondering, is she having problems with her Wi-Fi or whatever? She certainly informed me that she was going to be included, and I think you read her name out earlier.
Yes, Chair, if I can just reply to that. We're trying to get hold of her at the moment. Mr. Corney's trying to help me with that, and we're going to give her a call in a moment.
Okay,
Thank you very much. Thank you.
excellent. That's very helpful, both. Okay, so back to the agenda. Those are a summary of the people that we're going to be hearing from and roughly the order that we'll be taking them. So if I may ask the licensing officer to provide her report, please.
Morning, Chair. You've got me today rather than Jasmine.
Okay.
So there are no changes to Jasmine's report. However, 3 additional documents have been provided to the subcommittee and to all parties. These are the licence premises plan, an area view of the premises and surrounding properties, and some proposed conditions and an entertainment management plan submitted by the licence holder. As these documents have been provided to all parties in advance of the hearing, they are admissible today and can be referred to in the hearing. Other persons are reminded they can only make all submissions based on their written representations. Whilst they can expand upon points made in their representations, for example, further evidence that's come to light since the representation was written, they cannot introduce new information that wasn't originally referred to in their representation. As an example, if the representation referred solely to public nuisance, they cannot now introduce matters of crime and disorder unless the subcommittee asks them a specific question of their experiences relating to the premises. Any parts of the representations that have been redacted are not relevant and must not be referred to in today's hearing. Just to summarise, to make it easy for all of the parties, some of which may be attending their first hearing, today's hearing is limited to the narrow consideration of the 4 licensing objectives. They are the prevention of crime and disorder, public safety, the prevention of public nuisance, and the protection of children from harm. Any matter not relating to one of those objectives cannot be considered by the subcommittee. I'd also like to remind everybody that live and recorded music was deregulated between the hours of 8 AM and 11 PM on a licensed premises. So existing restrictions preventing outdoor entertainment that were originally placed on the license are automatically disapplied during those hours by virtue of that deregulation. If the subcommittee think it is appropriate, based on all available written and oral evidence, to place restrictions on outdoor live and recorded music, they would need to remove that deregulation by placing a statement on the licence that says section 177A of the Licensing Act 2003 does not apply to the conditions restricting timings of live and recorded music. That's a formality, but it removes the automatic right to deregulation and then allows you to make any restrictions that you feel appropriate with the deregulation removed. Similarly, any condition that exists on the licence that you would wish to take effect, including any amendments or any new conditions, would all have to be followed by a statement saying section 177A of the Licensing Act 2003 does not apply to this condition. That way the conditions wouldn't be subject to deregulation and would take effect. I'm happy to answer any questions either now or any time during the hearing. Thank you, Chair.
Thank you very much. I'm glad that you're happy to answer questions, because if Mr. Miller or any of the other persons have questions for the licensing officer based on the report that he has given and that's been provided in the agenda pack, now is your opportunity to ask them. You can either raise your hand physically, or if you look at the participants button and open that particular window pane, you can raise a digital blue hand as well. And I will keep an eye on both your camera screens and that little pop-up window as well for questions. Yes, okay. I can see Gerald's raised his hand, but it's not his turn yet, so I'm going to hold Councillor Morris until his part. And I can see Mr. Miller would like to ask a question.
Does this mean that we can bring up the actual terms of the licence as have been listed in the terms of the meeting? My opinion is that everything that I'm going to say depends on being able to speak about the terms of the licence. Is that okay?
Do you want me to answer that, Chair?
I think it would be helpful, Steve, please.
Mr. Miller, as you requested the review, you're entitled to bring whatever evidence you feel appropriate to the subcommittee's attention. You do need to bear in mind what I just said about live and recorded music being deregulated, so existing licence timings for live and recorded music and conditions do not currently apply. They were disapplied across the country by an amendment to the Licensing Act. So if you feel that those timings and those conditions are appropriate to be reinstated on the licence, it would be for you to demonstrate to the committee sufficient evidence for them to remove the deregulation and do that.
But where does this stand? Where do we stand under Annex C of the licence?
Give me an example of what you're trying to say. I don't really understand your question.
Annex C states quite categorically that the premises licensee holder shall ensure that there shall be no external regulated entertainment. That's there in black and white in the licence. Does that apply?
That's what I've just said twice. Live and recorded music is currently deregulated. That condition only applies to regulated entertainment. So that condition doesn't apply to live and recorded music, hence the reason that live and recorded music, I believe, has been taking place in the garden. That condition has been disapplied nationally by the government. Your opportunity today, if you have sufficient evidence, is to try to convince the subcommittee to remove the deregulation and either reinstate those restrictions or alternative restrictions.
Okay, lovely. Thank you very much for the clarification, Steve. And thank you for the helpful questions, Mr. Miller. I think that is something that it's useful for us to bear in mind as we move forward with proceedings. Does anybody else from the sort of applicant and other person's side of matters have a question for the licensing officer? I'm seeing no hands, in which case I need to ask Mr. Warne and Mr. Scahill if, as respondents, they have any questions that they'd like the licensing officer to address at this time. I see one
None from
no,
me.
and no from Rob as well. Lovely. In which case then I shall come to the panel who may ask questions of the licensing officer, and I believe that Councillor Morris indicated first.
Yes, thank you, Chair. Mr. Cobb, should we be mindful to remove the deregulation? Is that a permanent fixture, or would the subcommittee then have to meet again to reintroduce the deregulation? If you understand my question.
Yeah, the deregulation is an automatic allowance for every license. If you remove it, it has gone. The only way that I could see that you would be able to then reinstate that deregulation is if the licence was either varied on review or on application, to remove the conditions that are followed by the wording section 177A doesn't apply, which would by default reintroduce the deregulation. It may be that you should ask that question of the applicant's representative as well, because there is an argument that once the deregulation is gone, it is gone. And so it'd be interesting to hear his view.
Thank you.
Chair, would you like me to come in then?
Yes, if you would, that might assist briefly.
I can assist briefly, and I actually come from this, and I'm embarrassed to say I helped draft the legislation. So for those councillors who hate the deregulation of live music, and I know some of you do, I'm afraid, I'm partially responsible for it. The way it's drafted is, I think, as you have heard from your licensing manager, albeit you'll see in the proposal that we're proposing some conditions that would fall away automatically at the end of any COVID period. So if you were to disapply the section 177A exemption to those conditions alone, then that would fall away, in my view, at the same time as those conditions. If you were to apply it blanket across the license, it is, as the licensing manager says, something that I think would then require us to go back. But the reason I drafted the conditions as they were, with some that fall away, was that I anticipated you may want to consider adding section 177A for the purposes of those conditions in this case.
Okay, thank you very much. I think we'll make a note of that for discussion at the appropriate point in proceedings. I just want to note as well that Jane O'Brien, who was struggling to get in earlier, has now managed to join the meeting. And just to let you know where we are with things, we've heard from the licensing officer and he's explained the report to us, and we've just taken questions from the applicant for the review, Mr. Miller. There were no questions at that time from any other person supporting the review or opposing the review, and we have asked questions of the licensing officer so far from one member of the panel. I don't have any questions for the licensing officer at this point in time. Councillor Allen, did you have anything that you needed clarifying? No. Okay, great. I can see Mr. Corney has raised a hand. I'm not necessarily minded to deviate strictly too much from procedure today, but I will hear very briefly what you have to say.
It was just, I wanted to ask a point of clarification for Piers. You mentioned that the deregulation you felt would fall away after the...
Can I ask you, because I think that this might be more relevant to the respondent case later on, maybe just make a note of that question, put a pin in it, and we'll come back to it and you can explore it a bit more in detail at the appropriate point in the sort of procedure, just so our minds don't get muddled. Okay, lovely. Thank you very much. Okay, in which case that concludes our questions for the licensing officer. I think Mr. Cobb's got off lightly today, which is fortunate for him. And can we move then to hear Mr. Miller's submissions on this case, bearing in mind the guidance that you've received from the licensing officer about what this committee can and cannot consider today?
Yes, good morning. Good morning. My name is Fred Miller. I'm 83 and I live with my wife at 38 The Sycamores. I've lived there for over 34 years. I expect you have read my reasons for this application, and I have no reason to repeat my anger and frustration. Having heard what Mr. Cobb says, the only thing that we can do is apply to remove the deregulation on the terms of the behaviour that has been going on within the pub garden. The offensive nature of the language, the obscenities, and the general attitude towards us, the neighbours, has been appalling. I see absolutely no reason whatsoever why we should have to put up with this sort of behaviour. So it's a straightforward case. Please remove the deregulation and let us have the terms of the licence as they originally were written applied. Please. Thank you.
Thank you very much. That was exceptionally short and sweet, and I think you made your point very clearly. Well done, Mr. Miller. Firstly, I need to ask if anybody who supports Mr. Miller's application has any questions of fact for him about either what he said today or the documents in the agenda pack. I see no physical or digital hands, so I shall now ask whether any person...
Councillor Allen, Chair. Sorry, Councillor Allen.
No, Councillor Allen. Daniel, it's not your turn yet.
My apologies, Chair.
Oh, thank you. Okay, lovely. So any persons who do not support the review, do you have any questions of fact for Mr. Miller? This doesn't include at this moment in time the premises licence holder, just the those opposing the review of the licence from the public. Nope. Okay. And then I need to ask Mr. Warne and Mr. Scahill as the premises licence holder and representatives, whether they have any questions of fact for Mr. Miller.
No, thank you, Chair.
No, thank you. Lovely. Okay.
None for me.
None for you. Excellent. Thank you very much. Okay, so now panel members, Councillor Allen, do you have a question for Mr. Miller?
I do, Chair, sorry. Mr. Miller, you've commented, and I don't want to hear exactly what it was, that there is complaint over the offensive language and attitude. We're talking about the music aspect and the sound aspect coming across. Is this offensive language in lyrics from songs or offensive language during quizzes that's coming through? That's all I want to know, if it's from the entertainment side of it.
It is, I cannot recall anything offensive in the music, in the songs. No, I cannot recall that at all. It has all been by whoever has the hands of the microphone, and of course the worst has been the quizzes. Absolutely appalling. And we got children around here. No, there's no need for this sort of behaviour at all.
Thank you very much.
Thank you. I was just making a note, but I was definitely paying attention. I can see Councillor Morris has raised his hand. Do you wish to ask Mr. Miller a question?
Yes, please. Thank you, Chair. Mr. Miller, you live at number 38, is that right?
That's correct.
Okay, I may have this wrong, but I've plotted the location of all the people that have either supported you or not. I can't see any. Your neighbours don't seem to have submitted anything. Is that correct? Either side of you, one way or the other. Am I right there, or am I wrong, please?
On one side, yes, they have submitted, and on the other side, there is a Sikh family who are very reluctant to take any action whatsoever on this sort of thing.
So 36, 37, would that be 37 you're talking about?
I'm talking about 37, yes.
And what about 30? Is it 36 next to them?
36 next to them, they don't have any children and are quite happy to put up with whatever it is that comes over the tannoys.
Okay, fine. Thank you very much.
We've got we've got Lee, who lives next door. He's the one with the daughters and has the biggest grounds for complaining about the abuse and obscenities.
And he's at 39?
He lives in 39, yes.
Okay, thank you. I'll try and find his correspondence. Okay, thank you.
Okay, thanks, Gerald. Was that the end of that particular line?
Yep.
Yeah, okay, I think I know what you were achieving with that, so that's okay. Does anybody else on the panel have further questions for Mr. Miller? No, lovely. Okay, and again, I don't have any questions for you. I think you've expressed yourself very clearly in your submissions. So if I could now ask for, oh gosh, I need to ask the other persons in turn to present their submissions to the subcommittee. So I think we will be starting with those persons who support Mr. Miller's Mr. Miller's review of this application. So if any of the residents who have written to the council about this particular matter would now like to add to the statements that they've made or provide us with further additional facts to consider, bearing in mind the narrow scope of the licensing objectives, now's your opportunity to present in person to the committee. If you raise your hands physically or digitally, I'll take you in the order that you raise your hands if anyone wishes to contribute. I've got a yellow box that appeared briefly around Jane O'Brien's name, but your camera's not on, so I can't see you. Did you want to make a contribution and submission at this time?
Hello? Can I be heard?
I can hear you, yes.
Okay, I'm just trying to get my camera working. It's just not playing ball today, unfortunately.
That's fine. If officers are happy for us just to have this submission via audio, I am happy to take it, given we're all limited.
Okay, so we live at 41 The Sycamores on the corner. So our house backs onto the pub garden. There's me, my husband, and we've got two very young children, 11 years and 7 years. My youngest son's bedroom backs onto the garden. So, I mean, our issue is we would like to find a compatible arrangement. I appreciate, the pub has a business to run. It's very tough times. So, from our perspective, we'd like for our son, when he goes to bed at sort of, 8 o'clock, not to have the music blaring out across the garden at that time. And physically, we are, we are the furthest end away from the outside facility that has been built in these times. But we can still, from my son's bedroom specifically, we can still hear very, very loud music. And obviously the language is a little bit of a concern as well, given that he's only 7 years old. We weren't able to open the windows in the summer, so that obviously he was in a situation where either he had to go into the front bedroom with his brother, which isn't really what we want, or he actually can't get to sleep. So my concern is, the loudness. Whilst we bought a house, next to a pub, and we understand the pub needs to operate a business, we understand these are exceptional times. We didn't buy a house next to Wembley Stadium. So, so it's the outdoor music venue the operations that are actually taking place at the moment that concerns us. But we also, to be honest, we have frequented the pub in terms of having Sunday lunch there, very enjoyable. But we need to find a way to work for this to work in a compatible framework. And my concern is the lateness in terms of the loud music, and the fact that we are at the far end, and it still interrupts our life essentially when these events are taking place. So, those are the feelings of both myself and my husband.
Okay, thank you very much. I think that's helpful for us. I can see Mr. Corney has raised a hand as well. Before I come to you, I need to run through the same sort of questioning procedure as we did previously. So very quickly, do any of the other persons who support the review have questions for Jane? No. Okay, and any other persons who oppose the review of this licence, excluding Mr. Scahill and Mr. Warren? Do you have questions for Mrs. O'Brien? No. Okay. Can I ask that? Have I asked Rob? No, I haven't. Can I ask Mr. Scahill and Mr. Warren? Do you have any questions for Ms. O'Brien? No. Okay. And does the panel have any questions of fact for Ms. O'Brien? I can see Gerald. I'm going to ask a question first, though. If you don't mind me asking, Jane. Firstly, how long have you lived close to the orange tree? And secondly, have you ever needed to move your son's bedroom?
So we've been here for just over 10 years now. And so there was, I think there was either a year or a couple of years before Rob actually took over the venue. I'm sure he can clarify that. But yeah, we've been here. I think we've been here about coming on 11 years now. My son's 11. We moved here. Yeah, so that would probably be right. And have I moved him? Yes, he's moved into his elder brother's front bedroom once over the summer. So it's not a regular thing, but we just had his window closed. And, you know, he goes to bed at about 8 o'clock. We were pushing his bedtime back, but obviously he didn't go back to school. So there was a bit of flexibility. Had he been getting up to get into school for 8 o'clock, because we both work and he has to go to a breakfast club, so he has to be up very early, then that would have been really problematic, because he was finding it very difficult to sleep. And obviously I don't want him exposed to some of the language that, you know, that kind of comes out. I mean, from our perspective, it was more the very loud music than the language, because our, as I explained, our houses are actually on the corner and we are at the farthest end of the pub garden, so not directly behind the bar that has been built outside.
Okay, lovely. Thank you very much for that. Councillor Morris, did you have a question for Ms. O'Brien?
Thank you, Chair. Jane, you've obviously got two issues: the noise and the language. If there wasn't the bad language, would you be somewhat more relaxed about the issue, bearing in mind that obviously this is very much COVID related and hopefully will go away in due course? So
yeah, I mean, look, my husband and I completely understand this is very difficult times for pub landlords, and we, you know, obviously, you know, the business needs to kind of keep going, but we've had a discussion about it, and it's, you know, it's more of a compromise that we need on this, like, you know, to work together with the business, it is primarily the noise, as I say, with the language. And he's only 7, so, you know, maybe he wouldn't understand some of the stuff that's kind of coming out of there, but it is primarily the noise that kind of bothers us and would bother him as well.
Okay, thank you.
Okay, thank you very much. So if the panel have no further questions for Ms. O'Brien, I shall turn then to Mr. Corney. I believe you wanted to make some oral submissions to the panel.
Yes, thank you. I've submitted in writing, so you can see that there, I suppose in support of Mr. Miller, we too have children. We have a 3-year-old, a 6-year-old and a 9-year-old. It's been exceptional times over the summer. It's been hot. We've had to have all the windows closed and had some difficult conversations with the children around the language and what they're hearing. We've tried things like air conditioning to help, but it hasn't helped, and the children haven't slept well, and it's made it, you know, very generally difficult aside from the COVID situation. We did call Rob about that and kind of expressed our wish for the music to be reduced. Rather, we feel that we're trying to work with Rob on that. We were told it's my statutory right and that's what I wish to do. That made it challenging for working together. So yeah, I'd just like to echo the points that Jane's already made and Fred's already made, that it's been a challenge, and we've been trying to work through this amicably, and we've not been able to reach a point of that to date. Thank you.
Okay, thank you very much. I had a brief moment where I wasn't sure if you'd finished or if the screen had frozen. That's what that look of terror was. Okay, so same round of questioning again for Mr. Corney. Do any of those people who support Mr. Miller's application have any questions of fact for Mr. Corney? No? Okay, and do any... Oh, I can see Mrs. Miller's raised her hand.
Sorry, yes. One of the things that I was going to say to Mrs. Corney was that she actually instigated a WhatsApp group because she was worried about the effect of the music on my husband and I. She realised that we were an older couple and that perhaps this was affecting us badly, and I must say we've had many sleepless nights and, well, yes. But is this true, Kate, that you instigated this, the WhatsApp group because you were worried about us?
Hi, thank you, Maggie. I'm Kate Corney. Yes, I was really concerned about our neighbours nearer the pub because of the noise levels. Knowing that we were struggling with it ourselves, I wanted to find out how everybody else was doing. I guess it comes under the point about prevention of public nuisance, but it's also about the health and the well-being of the community. And the vulnerable, particularly the older and the younger, need to be considered, which is why we feel that we're sort of working together is the best option, and we really, really want to resolve this together.
Okay, thank you very much for that interjection, Mrs. Miller. I think that was an assistance to Mr. and Mrs. Corney. Okay, so do we have any questions for Mr. and Mrs. Corney from those who oppose Mr. Miller's review of this licence?
Chair?
Yes.
Sorry, Mr. Garnish just put up his hand.
Ooh, I did not see that. Thank you very much for that. Yes.
Hi, sorry, this is not a question to, it's my personal point of view. We live at 39, next to Fred and Maggie. I put in a complaint about the loud music. We also can't use our garden. Shutting the windows no longer works. We can hear it through the front of the house now. We've got 3 young children. Well, two children who start work early in the morning, 5 a.m., 4 a.m. I've also got a child in education. And the music is unbearable. I myself have also approached the landlord to try and work something. I was told it's a pub, get over it. The phone was slammed down, so I found it quite difficult this year. It's just an absolute nightmare. The quiz, the stuff we can hear the quiz inside our house. And it's just not acceptable for my children to listen to. Well, I've documented. I won't repeat it. It's not repeatable. I don't wish for the Orange Tree to close. I just want it to go back to normal. We've lived there for 11 years. And I've never ever called the pub, not once. But for a pub what's traditional, 320 years old. 3 months' work has just totally undone it. It's just been awful. So I mirror what my neighbours are saying. You can't. It's just we'd like to get to somewhere where we can find a common ground, but it's just unapproachable. So we've had no choice but to call for this. I just mirror what the neighbours are saying. Really, it's just yeah.
Okay. Thank you. No, thank you very much. I think we've cheekily managed to turn one submission into 3 submissions from people, but given that you're all sort of speaking of a theme and it's interconnected, I'm quite happy for efficiency to take this. So I don't think there's likely to be any questions of fact from those supporting or seemingly opposing the review. Therefore, if everyone's happy, can I ask Mr. Scahill and Mr. Warne if you have any questions for either Mr. and Mrs. Corney, Mrs. Miller, or Mr. Garnish? I see 2 no's. Okay, and now I shall turn to members of the panel. Do you have any further questions of fact for the 3 residents that we've just heard from? Councillor Allen.
Can I confirm the main issue with the language on the quiz night? How many nights a week is the quiz night held, and how many nights a week is live music held, please?
Would you like me to answer that? The quiz is every Tuesday
No,
night.
thank you.
Oh.
No, thank you, Mr. Scahill. No, this
Oh,
question is for the people that have just spoken.
Okay, sorry.
Okay, I can answer that. The quiz night is weekly. Apart from having a 3-day weekend for Glastonbury and a 3-day weekend for Woolstock, we have had sometimes music in the pub 5 nights out of 6. I have sent in data sheets to the environmental department, which I hope you've all seen because I included them in the review literature. They were sent in to be included. And this really covers most of August and some of September, I think.
Okay. Mrs. Miller, the question was, is it live music or is it recorded? That is the important question for me here.
Both.
Is it live music over the course of the 5 days?
Well, it's live and recorded. I mean, I can't distinguish between the 2.
Okay, thank you.
I mean, that's all I can say is live and recorded music.
Okay, thank you.
Yeah.
Thank you very much, Mrs. Miller. I think that answers Councillor Allen's question. Councillor Morris, did you have any further questions?
Thank you, Chairman. Again, a question for either Mr. or Mrs. Miller along similar lines to Councillor Allen. So you said quizzes are weekly. Does that mean once a week or 5 times a week? Mrs. Miller?
The quizzes are every Tuesday night.
Once a week?
Once a week on a Tuesday night, and believe me.
Okay, that's fine. Thank you. And music, whether it's recorded or live, is typically 4 or 5 times a week?
Typically Friday, Saturday and Sunday.
3 times a week?
Yes.
Well, no. If you look at my data sheets, it is more often than that. It's yes.
Okay, 3-ish times a week.
Sorry?
3-ish times, approximately 3 times a week.
Not if you look at my data
Okay,
sheet
fine.
in August and September.
Okay, thank you. Thank you very much. No further questions, thank you.
And I have noticed Mr. Scahill shaking his head at a number of points during that. I think the point to note for the panel perhaps might be that these are Mr. and Mrs. Miller's perceptions on what's going on based on the types of noise and perceived nuisance that they feel they are experiencing. And obviously, if Mr. Scahill wishes to provide factual corrections later on at the appropriate point, the panel will obviously welcome those confirmations. Okay, so bear with me a moment. Let me just check and make sure I don't miss anybody out. If we have no further, I can see Mr. Camp is raising a hand. Is this to make a submission? And just so that I know which side are you making a submission for?
I'm making a submission in support of Mr. Miller and
That
Mrs.
is-
Miller.
Oh, okay. Yep. So we're still in that place. So can we hear what you have to say? Obviously, if you sent written submissions, we've got those. And if I can encourage you to build on those submissions, as I would for all people speaking, that will assist.
It really goes back, and I think I may be the only one speaking this morning that was at the licensing hearing in 2012 where the current license was granted, and we spoke quite and considered quite considerably whether about noise that would be coming from the premises if and when live music was allowed. And as a result of that and our submissions, on behalf of several neighbours who were unable to attend, a condition was put in that licence of a noise limiting device, which must be preset, which would cut out when the level of music exceeded that level.
Right. I'm going to query relevance at this point in time with my licensing manager.
If I may submit, I think there is relevance, because my question, which I might have asked at the beginning, but I thought it was relevant to my submission, was whether that noise limiting device would then extend to the outside entertainment when that was allowed.
I think that's something that we may consider at some point.
I mean, if that had been the case, we may not be here today discussing this, because the noise levels were limited inside the premises, presumably with thick walls by that device, but clearly are not limited outside if that device is not in being. And with the marquee outside, the noise would spread much further than it perhaps would have done whilst inside the premises.
I think that's an option open to consideration going forward. We can't look at obviously historic points around that, but thank you for raising it.
I would also say that we've lived here for 45 years, and until the last year, with the consideration and the noise limiting device put in 2012 in the licence, we've not experienced any problems, but we live perhaps further away than some of those who have submitted, 150 metres perhaps from the pub. But it was possible during the music to hear virtually every word of the song that was being sung. And that really, if it's background music that you just hear, that may be fine. But when you can actually hear every bit of it 150 yards away, 150 metres away, that then perhaps indicates the unacceptable level of that noise.
All right, thank you very much. I know Gerald's got Councillor Morris has got his hand up. I need to see first and foremost whether or not any of the other members of the public have questions for fact for Mr. Camp. 3, 2, 1, no indications, okay. And whether or not Mr. Scahill and Mr. Warren have any questions of fact for Mr. Camp? No. And okay, Gerald.
Thank you, Chair. More questions, I'm afraid, for either Mr. or Mrs. Miller. Did you request, Mr. and Mrs. Miller, that an officer, is it from Environmental Protection or similar, come along to actually monitor the noise problem in your house during this period of complaint? And if so, could you tell us what actually happened?
I'm gonna be irritating and tell you off procedurally, because you know that question should have come higher up the agenda.
Sorry.
But if Mr. and Mrs. Miller can provide a very brief yes/no answer, we'll take it and we'll move on. This committee is aware that there is an ongoing investigation consideration into noise, I think, with environmental health, but we have received no submissions from our environmental health officers about noise nuisance. They've not raised a concern, so we shall take that, whichever way we choose to take that in our deliberations.
So we haven't got any information from the council as to whether one way or the other. Thank you.
No.
That answers the question.
In which case, Mr. and Mrs. Miller, you don't need to provide us with an answer. Thanks. Oops. There we go. I did not intend to mute myself at that point. I intended to check my agenda. Do any of those members of the public who oppose Mr. Miller's application for review of this licence wish to make a submission at this time? This is your only time to make a submission. If you think your written submissions speak adequately, that's good. I can see Mr. Gorm's hand, so yes.
You just need to unmute your microphone again, Mr. Gorm, if you could. I can't hear you at the moment.
All right, take your time. And then just for clarity, after we've heard from Mr. Gom and anybody else who's opposing this, we'll hear from Mr. Scahill and Mr. War. And I can see Mr. Gom's little mute symbol has disappeared. So would you like to try and speak?
Yeah, can you hear me now?
Yes.
Yeah, okay. I just want to support Mr. Scahill. He's a pillar of our community and has done an awful lot for Baldock. And I understand all the issues concerning us. I used to live next door to a pub, so I fully understand everybody's concerns. But I have personally attended a lot of the music events. And with respect to one like the Glastonbury weekend, I was there all day Saturday and Sunday. And both days finished on the time. Saturday finished sharp at 10 o'clock and Sunday finished sharp at 8 o'clock. I've also attended most of the afternoon sessions on a Sunday, and they've always finished at 6 p.m. So I don't understand a lot of the complaints about noise extending to late at night. But I just want to say, you know, I've lived in Baldock for 40 years and I've been around many of the pubs, and the Orange Tree is one of the best managed pubs. I've never seen bouncers on the doors. I've never seen drug dealing, and you can't say that for every pub in Baldock. So I just want to support Mr. Scahill and what he's doing. Yeah, we have a very deep reservoir of talented young local musicians who perform throughout the year at many venues, and during this exceptional period, they haven't had that outlet. And so for Mr. Scahill to provide that outlet is again strengthening our community spirit and saving lots of people from depression and other things, something I suffer from.
Thank you.
Also, I'd like to ask where the police reports are. If this is so bad and it's so antisocial and there's children at risk, where are the police reports? I've not seen anything from the police concerning these issues.
Okay, and this committee hasn't seen anything from the police concerning these issues either, which means that anything that might be said on it would be treated as anecdotal, and I will say at this point in time is not going to be considered as relevant to what we're going to be thinking about today. Obviously, at such future point, you're free to call for further reviews of licenses, etc., in line with normal procedures as and when evidence is available. There are no submissions from the police as a relevant authority either, just like we've had nothing from environmental health. Does that conclude your submissions, Mr. Gom?
Yes, I put all my other thoughts into my statement, which I presume people have taken the opportunity to read.
That's absolutely fine. Given there was a slight issue with you getting off mute, we're going to move to a round of questioning. So I'd say for you only, keep yourself off mute just so that we can try and manage things and run a bit more streamlined. I've seen a couple of hands pop up from Mr. Garnish, and I think Mrs. Miller indicated as well. I'm not in the business of facilitating arguments between residents. I can foresee potential scope for things to get heated. So if we could try and restrict things to questions of fact rather than opinion and conjecture, the committee would be grateful. Mr. Garnish, I think, indicated first and for longest. Would you like to go first?
Yeah, just a quick reference to that, the comments from the gentleman. We do have crime reference numbers, and we have had environmental round, and they had no equipment available, and they didn't turn up on the day they said they would turn up. And I've also had 2 people from the environmental in the house, both in full agreement that the music was way too loud, but they told me they were going to leave this to the committee. But
I'm going to cut this off here, and for the benefit of the committee, remind ourselves that this is not relevant. I think we're aware of the ongoing environmental health things, but we cannot comment on whether or not there is a police investigation. We'll take that into account because we haven't had representations from that relevant authority, I'm afraid. I'm really sorry. We have to be so hideously strict sometimes with things that are quasi-legal.
I have got crime reference numbers. I appreciate what your point.
I hear on a personal level, I hear what you're saying. On a committee level, I don't hear it. Okay.
Fine, no problem.
Okay, I'm really sorry. I hope that makes sense.
Makes total sense.
Yeah. Mrs. Miller, did you have a question of fact for Mr. Gom?
Well, I have my data sheets here, and I can I can actually say exactly what, I don't know which days Sundays are, I only have the dates. But there aren't many days when the music stops at 4 o'clock or 6 o'clock or whatever he said. There's certainly lots of days when they go up to 10 o'clock. But anyway, I have a submission to put to you later on, so I will include it in then if you would like.
I think Mr. Miller will be making closing submissions at the end once we've heard everything as well. So if you wanted to sort of have him contribute that at that point in time, I think a lot of the nuisance issues that we're hearing are very much not necessarily about the hard and fast facts and what's happening with the license, but a lot of it is more how the operation is impacting on residents personally. So I think that's sometimes why we're hearing different sides of the story from people like Mr. Gom, or what's on the paperwork that we've had from the pub, and obviously the contributions that residents opposed to things continuing the way they are is happening. And we are aware, and we will weigh that up when we think about what we're going to do with the decision we have to make today. Okay, so if there are no other questions of fact from members of the public for Mr. Gom, I shall ask Mr. Scahill and Mr. Warren if you have any questions for him.
No, thank you.
No, thank you. Lovely. And members of the panel, did you have any questions of fact for Mr. Gom?
No, Chair.
No. And
No,
Gerald is not.
no.
No. Okay, lovely. Thank you very much for that. Okay, so that concludes our presentations from those people licensing law coldly calls, in my opinion, other persons. You're not other persons, you're valuable members of the public. And we can move in this case to the premises license holders case. Oh, I can see Mrs. Miller indicating very briefly, I'll allow it.
I thought that I would be able to make a presentation as the other, the people that agree with Mr. Miller has. I have got quite a list here of the things that I object to.
Okay. I do apologise. I thought you had already made submissions to us, but if you've got on that list there items that are sort of novel and kind of build on what's in your written submissions prior and do not repeat what we've already heard from other members, I will, as an exception, begging the sort of extreme lenience of my licensing officers, hear it.
Well, one of the first things that I would say was that I believe that one of the councillors said that the bad language is not involved here, or the music is not involved here. Surely noise nuisance covers both speech and music. It's still a nuisance for whatever it is. It's still upsetting and distressing to the people who live around. What difference does it make from music to speech? I've really, you've restricted me now to quite a small input. In fact, I have some far more than that. But it seems that I missed my opportunity to agree with Mr. Miller.
I think it is noted by the panel that you agree with Mr. Miller, and I think we have noted the submissions that you've made at various points throughout today's hearing, and I can assure you that you have been heard, both in terms of writing and in terms of the presentations that you've made today. As I've said, we're aware that there's an environmental health consideration around noise that's ongoing, and we will think our thoughts on that when it comes to us thinking thoughts. And I think you've adequately demonstrated the impact that you're experiencing as a result of the pub's operation. If there are other incidents or items of fact that you think are absolutely pertinent and crucial to this committee's consideration that haven't come out elsewhere, please tell us them now. If not, I'm going to move on to hear the respondent's case.
Okay, well, I have my data sheets here, and I've been asked how many times a week that this music carries on. There was music on, well, entertainment of some sort on the 7th of August, the 8th of August, the 9th of August, the 11th of August, the 12th of August, the 14th of August, the 15th of August, the 16th of August, the 17th of August, the 21st of August, the 22nd, the 23rd, the 26th. We then went away just to get away from it. The 8th of the 9th, the 9th of the 9th, the 11th of the 9th, the 12th of the 9th, the 13th of the 9th, and the times that these ended were 2200, 2200, 2215, 2215, 20, 22, 2030, 2230, 2222, and 2215. I hope that gives you a view of just a short period of the noise nuisance that we have had from the said pub.
Yes, I think that adequately demonstrates to the committee the impact that you have experienced as a result of what's been happening. Okay, I'm going to. Okay,
The other thing is, yesterday, last minute again, we were giving a new set of proposals, the plan. Nobody has actually mentioned this new plan yet, certainly not in any detail. Are we going to be able to have some sort of conversation about that later?
Okay, so this new plan that you're referring to, I'm assuming, is this something that has come from the pub?
It was distributed to us by email from the council yesterday afternoon. Well, we certainly picked it up at 3 o'clock yesterday afternoon.
I think if I could have some assistance from officers, are these the
Chair, sorry to interrupt. There's a proposed condition that came through yesterday that has indeed come from the pub or the pub's lawyer.
Okay. So I think what will happen then, Mrs. Miller, if I may assure you, the next person, once I'm permitted to move us on, who's going to be providing submissions to this committee is going to be Mr. Warren on behalf of the pub, and then secondarily Mr. Scahill. And I'm certain that should the pub wish us to consider different conditions as assistance to neighbours and residents, then they will be raised at that point, and they will be adequately discussed and debated, and you will have the opportunity to ask questions. Just as each time we've heard from a member of the public, I've offered them the opportunity to question you and they've chosen not to. So that's the opportunity in the proceedings. It's just the nature of these things that the applicant's side tends to go first and the respondent, by nature of being a respondent, responds. Okay?
Yes.
So, all right, good. So I think that we're done hearing from both the members of the public who support the application for the review and the members of the public who oppose the application for review. I will therefore move, if we are all happy, to consider the respondent's case led by Mr. Warren. Before I do that, I've been made aware that Councillor Allen can, or for a moment in time, could no longer see or hear proceedings. Are you okay? Are we happy to continue, officers?
I just wanted to let you know that I did drop out, but I am here.
Okay. All right then. I'm not having any kind of official notice to tell me not to carry on. So if I could then ask Mr. Warren to present the respondent's submissions, please.
Thank you very much, Chair, and I hope everyone can hear me from this horrible headset. And yeah, don't like these things, so I never quite know how they work. I much prefer these in person, it has to be said. Just so you're aware, Chair and councillors, I'm going to make a short submission on the papers and some points that I want to draw out from those, and then Mr. Scahill, who is the DPS and operator of the premises, is going to make a short statement that, if you like, deals with all the factual stuff about some of the comments that have been raised by residents, and then I'll just do a very quick, if you like, rounding up of what we have to say in terms of the conditions, etc., and address your points, councillor. The first thing to say is obviously Greene King hold the premises license here. And Andy Turner, who's been sitting very quietly on this call, is the BDM, so he's the area manager who has responsibility of looking after this pub as part of the Greene King estate. Rob isn't a premises license holder, he's the DPS, so he's the designated premises supervisor, and has been in this pub since November 2010. So around the time actually that some of the residents you'll have seen in the review papers came to live in the village. There's a bit of synchronicity there actually. We've listened very carefully to everything that's been said. We read the representations and the concerns that have been raised, and rest assured we take these matters very seriously. My client Greene King work very hard with our operators to ensure that as far as possible premises operate, obviously to promote the licensing objectives, but also they work with operators such as Rob, who's held a number of licenses with Greene King, and we do find him to be a very good tenant at our premises, to try and ensure that as far as possible that we don't end up in these review hearings, and actually usually we're very, very successful with this. So let me just draw some matters from the papers that I think are crucial when it comes to making determination here. And apologies if I repeat bits and pieces, but I'll try not to. You're aware, obviously, and have mentioned there's no representations for responsible authorities, and we're all aware that there's an ongoing investigation with your environmental protection officers. Now, that would be normal given that there have been what we understand 5 complaints over the summer in relation to this premises, and I'd say that that's nothing unusual. What is slightly unusual is not to have a representation from the officers here. Now, obviously, you read into that what you will as a committee with your experience of understanding how your officers work and how they approach reviews or presenting evidence to you. That's something you know much better than I do. But what I'd say is this: we have worked with Rebecca Clark from Environmental Protection. This has been ongoing with Rob taking the lead. So this isn't Greene King taking the lead. This is Rob proactively taking the lead. He's provided requested information and agreed in emails over the course of November and December that when there was an opportunity, she would come out and carry out tests and try and agree levels of music that would, if you like, strike the balance that we're talking about here of the operation of the premises versus ensuring there is no public nuisance. Now, the reason I kind of emphasize public nuisance is that obviously your own policy at D11.9, which is page 13 of the papers, refers to obviously the council leading on what is a public nuisance, and we don't have the officer here, the experience here, to give you much more about that. But what I'd say is this as a general point: not all noise is a public nuisance, and indeed not all nuisance is a public nuisance. And as much as I understand that Mr. and Mrs. Miller may find that to be an anathema to what they hear and experience, and I've listened very carefully in particular to what Mrs. Miller said in terms of when she feels there has been noise that's been too loud. We have to deal with, as you have said yourself, Chair, the 4 licensing objectives, and the one that's crucial here, or the one that's in debate here, is prevention of public nuisance. Which leads me on to say this is about music and the quiz being outside since lockdown only. This is not about entertainment from inside the premises, and not indeed about entertainment that's happened in the garden in previous years. You've heard about the Glaston Tree Festival, and there's a festival in the village as well that I know plays a part in the local community. Those aren't part of this discussion. This is about what's happened since the lifting of the lockdown on the 4th of July, albeit I do understand there were complaints about the noise of building in the garden prior to that. But with respect, I think that's something that needs to be parked as not really relevant to the licensing objectives here. And we can see that very clearly that this is all about since the 4th of July in Mr. Miller's own representation at the very top on page 40. Mr. Garnish makes reference to it. In his papers at page 45, 11 years, no complaints. At page 47, he says this is not about inside. And then there's also some debate and some discussion you'll see in the papers, in the representations, about which nights cause any particular issues. It's not for some people everything that happens in the garden. So for instance, Mr. and Mrs. O'Brien in particular reference Friday nights between 6 and 9:30, or Friday and Saturday nights. Apologies to Mr. and Mrs. O'Brien. So again, it may not even be all entertainment outside that causes a nuisance across the board, and you've heard that from some of the people here today. And we're very pleased, and we think it's important to note that those parties making representations have said this is not about closing down the pub. This is about working together to try and find the happy medium and balance in what are extraordinary times. And I would say this, we all want to go back to what is normal. We all want to go back to what was working prior to July 2004, and you'll hear from Mr. Scahill about that more. But if I quickly draw upon, and I won't go into the detail of the representations that were made supporting the premises, because obviously a lot of those parties are here, and I'm very happy that they've taken time to do so. That should give you an indication of actually how much they feel the pub plays a part, an important part in the community. But I will say that in general, there are residents who live in the immediate vicinity who have made representations supporting the premises. There are people who quite candid in saying, yes, we hear a bit of music, but we certainly wouldn't say it was intrusive or loud. There are people who talk about Mr. Scahill himself as being a considerate operator, and the premises being well managed. Now, what that indicates to me, and I'm sure it does to you, is that there is a mixture of views here, and people have different sensitivities and work in different ways. The job here is about trying to achieve that balance, I submit to you, and actually ensuring that we reach the right balance between the importance of live music, especially in these sort of really difficult times where people, as you've heard obviously from Mr. Gom himself, this has been a bit of a lifeline, having some live music, some entertainment, a little bit of normality in what are very difficult times, and for the musicians and other people as well who have benefited from this. And that's reflected in your own policies at B6, B7 and B9, which are pages 9 and 10 of the papers. No need for me to go through them. I know you know them probably like the back of your hands. And indeed, you recognise that in these kind of review situations where there are these competing interests, at page 15, E3.9.3 of your policy, that suitable control measures should be looked at in the first instance. And that's what we're hoping we can agree here and submit to you as being the appropriate and proportionate response to this review. We have to recognise that COVID is temporary, otherwise I think we'd all go mad if we thought that we'd have to live like this for prolonged periods of time. It's driving me nuts, frankly, having to work from home, and it's doing worse to other people. Just this week we've had everything changed again from under us, and we're scrabbling to catch up as to what this is going to mean. But I don't think any of us would say that the hospitality industry isn't one of those that has been the most profoundly affected in terms of the ability to continue business. So Mr. Scahill's done an incredible job, it has to be said, of trying to provide some succor through these times. And he may have got the balance wrong, and I think he's going to be the first to admit it when he speaks to you, but that's not the point here. The point is about trying to reach that proper balance. So if we assume that COVID is temporary, I will make some comments about the conditions I put forward in a minute, but I think it's probably a good time to hear from Rob himself, if Chair, if you're happy for that.
I will happily accept that it's the appropriate time to hand over to Mr. Scahill, and then once you're finished, if you want to bounce back to Mr. Warren to provide details about those proposed conditions.
Okay, thank you. I'd like to start by saying that I welcome this opportunity today to review the boundaries in which we can operate at the Orange Tree. And when I mean we, it's because we're discussing today, these does not affect me personally, just me personally. It also affects the lives of my eating staff, my loyal and regular customers, the various community groups that meet here, our local musicians, all of whom rely on my 340-year-old pub as a place for entertainment, solace, support, and equally importantly, income in these unprecedented times. Having said that, I fully appreciate that my immediate neighbours are equally important, and I have a responsibility to ensure that the right balance is maintained between my business and their rights. I'm also now aware, which I wasn't before, that I have not got that balance right, and I apologise unreservedly to those people that either consider my actions intrusive or offensive, as that certainly wasn't my intention. On the 21st of March 2020, lockdown 1 meant that we had to close when it became apparent that we would be getting significant financial support from the government and from Greene King in the form of paying no commercial rent. I didn't feel it right for me just to sit back and take the money. I kept my doors open for off sales and within a few days opened a grocery shop to help the local community. I continued to do our weekly quiz. I started free Saturday bingo and we moved Baldock Float Club into the virtual world. We provided takeaway food, delivered hot and cold meals and supplies to the vulnerable, shielding and frontline workers. I also decided I wanted to try and support local musicians, so decided that actually I would give the money away from the operation that we did, and to date have raised nearly £30,000. But even during that time, there were a small number of people that would criticise what I was doing, either on social media or through local gossip, and even a couple of anonymous phone calls criticising my decision to remain at training. But I've never been able to please all the people all the time, but the vast majority of people seemed grateful. On June the 22nd, Boris gave us an opening date of July the 4th, along with guidance that pubs should look to make as much of their outside spaces as possible, to build outdoor bars and stalls, and to do much as we can to avoid the need for customers to go indoors. Along with other forward-thinking pubs who got busy repurposing car parks, sheds, garages, erecting marquees, with the hope of providing safe, comfortable and dry environment for their customers in preparation for the usual challenges of the Great British Summer. We began work on converting our Patank Piste and its shelters and the adjacent garages and storehouses. We erected a 12-metre by 9-metre marquee, created booths and installed COVID-safe seating, installed a bar to remove the need for people to enter the pub. We even hired outside toilets, which meant the public bar indoors could remain as the community shop. We opened on July the 4th, and the customers started to return, happy to be in such a safe and comfortable semi-outdoor environment. We started to host the quiz on Monday nights and Tuesday nights, and Baldock Folk Club returned every other Wednesday. I wanted to be able to do more for the musicians though, because although the lack of money was affecting them, the mental anguish of not being able to perform their craft in front of an audience for 15 weeks was taking a more serious toll. We decided to start some Sunday afternoon semi-acoustic sessions with G. La Roche playing the first on Sunday the 2nd of August from 4 till 6 p.m, what we believed to be a reasonable and sensible time. This was warmly received, and we decided to keep those semi-acoustic Sunday sessions going. But I wanted to do more, as there were still a lot of musicians wanting to play, so working with the Balstock team, we decided to run a 2-day music festival in the Marquee in August, turning one of the booths into a stage, and to get those musicians that we had supported, plus others who, though financially stable, also craved to play live again. I worked closely with North Arts Environmental Health and Hertfordshire Police on how the event should be run, the management of the audience, and what sound levels we should follow. I must admit that I was more concerned with complying with the COVID legislation, not so loud as people have to shout to be heard, and worked on the assumption that if we followed that rule of thumb, we would be within the acceptable limits for our neighbours. We also ensured that the music finished at 10 p.m, along with the restrictions, although no longer enforced since the 2015 deregulation of live music that were on our licence. For instance, we were allowed to have live music playing in the garden with our conservatory doors open once a month until 10 p.m. on our previous premises licence. The Glastonbury event was a great success, raising over £3,000 for the musicians that played, and earned praise from a senior North Arts Environmental Health Authority for its compliance. We believed we had a safe and acceptable formula for running those live events, and we had another festival in September over what would have been the Balstock weekend. We had a number of weekends where on a Friday or a Saturday, and once on both Friday and Saturday, where we'd play some live music with live bands. But for the statement of fact, the quiz is every Tuesday, the folk plays every other Wednesday, and outside those times we play recorded background music with a 85 decibel limit on it. On the 23rd of September, the government announced a new set of restrictions, including the requirement to offer table-only service and for people to remain seated whilst eating and drinking, which I meant I had to take another look on how we're operating, how best to safely and efficiently serve our customers in comfort. Now, in the period between the 4th of July and the 23rd of September, we only had 5 telephone complaints and no personal representations. All the telephone complaints were anonymous, and 2 in which the call was quite offensive to my staff. As I've already mentioned, there have always been a few people that do not like what we do at the Orange Tree, whether for valid reasons or otherwise. I had been experiencing some trolling on the internet, people claiming that I had been taking the musicians' money, or had been earning money during lockdown, or making my furloughed staff work and so on. So I genuinely believed that those unidentified callers weren't my immediate neighbours and that there were just spite involved. I have to add, I was shocked, only finding out today, and when the submissions were put in, that they were in fact genuinely neighbours with genuine complaints. It's just a shame I wasn't aware it was actually who they were. There is to say no smoke without fire, so I also began to look at how we could reduce the sound levels whilst continuing to run a viable business. The side of the marquee facing the garden had been left open so that people in the garden could sit and listen to the music. So we made it fully enclosed by installing a perspex wall and double doors. We put a sound limiter in and a more distributed speaker system. We employed a noise monitoring device and stuck rigorously to the 85 dB guidance for recorded music and the not too loud to shout rule for live music. I believe these changes further reduced the noise coming from events in the marquee, and we continued to run music events until we entered lockdown 2 at the beginning of November, the final event being a celebration of my 10-year anniversary of being at the Orange Tree. Since then, due to the restrictions, the marquee and garden has remained closed, as it will be for the foreseeable COVID-affected future. My guess is April. I have to say, throughout those times, all those times, I was completely unaware that we were having any significant impact on the neighbourhood. I'm of course fully aware that we make noise, like any pub does, but honestly believe we were operating with acceptable limits, given the circumstances placed upon us. I kind of hope that maybe if one of the neighbours had come round and had a chat, I could have taken it on board properly. And I apologise for, even though I didn't know who was on the phone call, for being maybe a bit short with them. I will also admit that the quiz is at times quite adult. As quizmaster, I do not hold back in terms of saying what I think about things, sometimes politicians, particularly Donald Trump, and my language can be a little rude. I can also say, though, in all honesty, that I've not been inciting my customers to take sides against residents. That makes no sense, given that everyone knows each other. And I also would like to say that I do not believe at any point I was ever offensive directly to my neighbours. I generally try and thank them for their support. It came as a complete surprise to me that this review was requested, but I reiterate that I see this as an opportunity to reset what we do now in that marquee, how frequently, over what times, and to establish an acceptable and fair way forward. To that end, in December, I hand-delivered a letter to all residents in the immediate surroundings, apologising for disturbing them and reminding them that they could and should make representations, good or bad, to the local authority to give a full picture of what I've tried to do here and whether it has worked or not. I was very pleased to see that this has happened and that these have been submitted for the committee to consider. I've been working with Rebecca Clark from NHDC Environmental Health on how we can arrive at acceptable operating levels, although the restrictions since November have put this activity on hold, as I would have liked to have been able to feed the results into this hearing. I would like to reassure residents and the committee that I see this as a top priority, that we complete this work in a real live environment as soon as the restrictions allow, and that Rebecca is also happy to come out and carry out tests with my neighbours on the levels as soon as it is feasible. For that reason, I would ask the committee to please put the 4 conditions on the premises licence that have been proposed by Greene King as licence holders. I have submitted them through the draft music management plan. Of course, this will change as the regulations change and will also need to be amended to follow noise testing with Rebecca, but I hope it gives you an idea of how seriously I take these matters. I would like to reassure residents that as soon as I possibly can, once this pandemic has been defeated, I will move the folk club and the quiz back indoors, along with the majority of our live music events. They simply aren't suited to being in that environment. Our 4 local petanque teams will be able to get their piste back in the week, something they desperately want. And at the weekend, the marquee will just be for drinking and eating, and with a fair wind, watching my beloved England rugby team in the Six Nations. We would still like to run a small number of festivals and the Sunday semi-acoustic sessions in there, and I'll absolutely ensure that we do this in a compliant and acceptable way. I'd just like to make a quick point on the difference between live music and recorded music. We do play recorded music during opening times in that marquee, and I apologise again if it has been too loud. The 85 decibel link limit that we've been following, if that is too loud, obviously means that we will reduce it. But I will also say that the actions we took in September, blocking off the marquee completely, would have made a significant difference to how loud it was in the garden and for our emerging neighbours between July and August. Finally, I would like to reiterate that I've tried to follow the guidance I've received from the council. And although I am proud to have given our local musicians not only the financial support they needed, but also the chance to perform that they crave, I am sorry that some of the residents found this too much at times and genuinely look forward to reaching something that is acceptable and that gives me more concrete measures to work to. Thank you.
Thank you, Rob. Sorry, can you hear me again? Just
Yes,
double
yes,
checking.
We can hear you. Thank you very much, Mr. Scahill. Mr. Warren, do you want to build on those conditions? And
Yes, I just very, very quickly. We've discussed already whether the Section 177A exemption needs to be removed. I've drafted the top two conditions, which, if you have them in front of you, are to be permanently applied to the premises license. So these go way beyond, if you like, the scope of the review, which is COVID related, to have a proper entertainment management plan. We included a copy of it, but as Rob says, that's obviously liable to change as we get the Environmental Protection Officer in, for instance, and also as the COVID regulations change, etc. And then when we go back to normal as well, we still have to draw up an entertainment management plan. But as you've heard, we expect to put most things back inside, go back to how things were. A complaints log is just very, very sensible because there is this, if you like, difference of opinion about how complaints are best presented. And what we want to do is avoid there being any conflict in the future. So if people do phone up and complain and can give us details of who they are, those are recorded and logged, and your officers are able to see what's there. If then residents say they're complaining and nothing's being done, there is a log that everyone can refer to. The second two conditions have been drafted to apply during the period of the COVID-19 restrictions. We've been doing a lot of this, as you can imagine, around the country for publicans, where they have various conditions on the license that need to be either removed or added or changed for the period of COVID. So it is something that is accepted as being a means of working through this period, having temporary conditions or having conditions that are linked to the COVID pandemic itself. And the idea of it falling away automatically prevents everyone having to come back and reapply, put notices up, possibility of objections, and frankly taking up people's time where it's unnecessary to do so. You'll see that we've limited the number of music events and quizzes by the second of those conditions. And you'll see, probably more importantly for the neighbours, that what we're saying is we won't provide any of those live or recorded music events until such time as there has been a chance to test the levels with the Environmental Protection Officers to set a level that's appropriate and works for everyone. Let me be perfectly frank about this, because we don't want to pretend that this is the panacea for everything, but what we're dealing with here is an attempt to balance a very, very difficult situation for all parties. COVID's once in a 100-year event, and everyone has been rushing to catch up at various different times. So what we've put together, we hope, is an appropriate and proportionate approach directed at the issues that have been raised, and is practical to apply for Rob and his team, and hopefully will give the residents some comfort. I'll save any further comments for summing up, but would invite you to ask any questions you may have at this stage.
Excellent, thank you very much both. Now, before I ask Mr. Miller if he has any questions as the applicant for this review, I just sort of wanted to pull out. Rob provided a lot of information about what's been happening at the Orange Tree over the last nearly 12 months of this crazy period that we've all had to deal with. All of the stuff about being a paragon of the community and the charitable work, etc., is not relevant to this committee's consideration. We're solely concerned with the public noise aspect, and I think Rob does know that. I didn't cut you off because I thought it was a very worthwhile thing to have in the public domain, but we won't be taking that into consideration. All we're going to think about is what you've said around the noise issues, the live music events, the quizzes in the garden, And then also thinking about those proposed conditions as well, and whether those are sufficient to alleviate the noise nuisance that residents have been experiencing over this period of time. So my point to Mr. Miller is, bearing in mind what this committee is going to be considering, could we ask that all questions are kind of focused on that more sort of narrow angle, and we're keeping things to matters of fact rather than opinion and conjecture in this round of questioning. Okay, so as the applicant, Mr. Miller, do you have questions of fact for Mr. Scahill and Mr. Warren?
Will I be given a chance to speak at the summing up?
You will also have a chance to speak at the summing up, yes. So just as a reminder from the procedure, we're at that point now where we've had the respondent's case. Everybody, we do the same round of questioning as we did when we heard from the applicants. After we've had everybody's questions, we then move to closing statements. So I'll hear from the licensing officer. If there's any legal points that have come up, we'll be advised as to the legal points. And then the applicant and the respondent will have their opportunity to make closing statements and something that's kind of like mini TV court drama style, if that helps understand the procedure for people.
All right, thank you very much.
Okay, so do you have a question for Mr. Scahill or Mr. Warren, Mr. Miller?
No, not at all. It's been a very polished performance from both of them. Well rehearsed. A lot of it, as you said, wasn't relevant at all. And I will bide
You're
my
going to
time.
hold till something. Okay, that's fine. I don't think that they needed their egos boosting, but I'm sure they'll appreciate your kind comments. Thank you very much. Any of the other people supporting Mr. Miller's application, do you have questions of fact for the respondent? I see Mr. Camp first, and then I see Mrs. Miller. So we'll go to Mr. Camp.
I just want to make it establish absolutely beyond doubt that once COVID restrictions end, any outside entertainment in the form of live music will cease in the outdoor area. Will it all go back inside the premises and be subject to the same noise limiting device that was part of the license agreement in conditions in 2012?
Shall I answer that? As Rob said in his statement, the idea is to go back to what was there previously. There would be, if it could be done, the Sunday folk sessions, possibly being held outside in the marquee, but that would have to be subject, obviously, to the levels being correct and working for all parties. But beyond that, and beyond the festivals that obviously happen outside each year and have done for years prior to COVID, the idea is to move the quizzes and the other music, as Rob set out, back inside again. This wasn't an attempt to turn the outside into inside permanently. It was simply a reaction to the situation under COVID.
If that were the case, would the license be altered? Because as I understand it, the license conditions at the moment are that everything takes place inside the premises, not outside.
I can deal with that, and probably helpful for the chair in just the legalities of it, because the reality is that the Live Music Act deregulated a lot of entertainment. So that condition that sat on the license from 2012 was deregulated in 2014 under the Live Music Act 2012, ironically. But that's obviously within the gift of the committee to consider whether actually there is any evidence that would relate to prior to the COVID, so prior to July the 4th, that would require any changes to the license permanently, if that makes sense.
Yes.
What my submission is, we're looking at the COVID period and dealing with what's here in front of us now, not how the pub operated beforehand, because from what we can see, most of the representations, if not all of the representations where they mention it at all, suggest there were no issues.
I mean, yeah, there were no issues before, really, COVID, but I'm just concerned this is a way of things continuing in the way they have been post-COVID without any control.
Yes, look, I think whatever the committee did today, and I'll be very quick, Councillor, just to answer that. If Mr. Scahill were to ride roughshod over anything in the future, whatever the decision is today, we would expect to be multiplied with a level of venom appropriate to someone who would ride roughshod over what the
I'm
committee
going
wanted
to
today.
stop this before we go too far, and I feel that Mr. Warren might be digging a hole and gazing into crystal balls. We're not going to deal with hypotheticals. We're going to look at the issues before us and the evidence before us in this place, here and now. I can't even predict what's going to happen next week at the moment. Can you? So let's not
Sorry,
go
Councillor.
too far into the future. Thank you very much.
One or 2 days is more than enough for anyone. I totally agree.
Exactly. So thank you very much for the question, Mr. Camp. I think that was a useful clarification for us to achieve. Does anyone else have a question? Oh, yes, Mrs. Miller did. Yes, I did write you down. Oh, you're still on mute if you want to take a moment.
Right. It's really not a question, it's a response to something Mr. Scarhill said. He said that he did not have any personal representations or anyone on the phone actually complaining. When Mr. Scarhill came many years ago, he came around to the house, delivered his personal card and said that if there was too much noise in the pub, to phone up, this is his phone number, and tell him. I phoned him, I got abuse, I got bad language.
Okay.
And I swore that I would never give him the opportunity to say such things to me again, which is why I haven't approached him over the recent matter.
Okay, thank you very much for that. I will raise with the committee that perhaps we shouldn't consider that as relevant to the question that we need to think about today. Do we have further questions for Mr. Scahill and Mr. Warren?
Yeah, there's two people with their hands.
Oh, yes, thank you. I saw Miss Smith, and I think, do you want to go after Miss Smith, Mr. Corney? Yeah, okay, Miss.
So I guess my question really was reiterating Mr. Camp's, but then I just had a point of clarification that I just wanted to make sure I understood on the proposed conditions that came through. So Mr. Scarhill has himself said that the nature of the quizzes is very adult and he doesn't hold back. But are you proposing that during COVID, if he can, he would still run those quizzes outside?
I can answer that question if that's okay, Piers. The answer is I don't know. I think learning from what I've heard today, and I reiterate, this was a bit of a surprise to me. I don't think it's appropriate that that would be done. I think I would continue to run them online. Obviously, we can't look at what's going to happen in the future. My guess would be, though, that if there was to be, unless we can move back to having the quizzes inside, I will not do them. I will not do them outside because, quite frankly, I wouldn't be able to do it with the thought that I am affecting particularly people's children, because that, breaks my heart. So, I guess all I can say is that I can give you my guarantee that we won't be doing the quizzes in that marquee because we have the ability to do it online. It's not very good, but it's better than nothing.
Okay, thank you.
Okay. Could I then take Mr. Corney?
Thank you. Yeah, sorry, I took a note of there was an 8 decibel limit for background music. Was that applied in the garden? I wasn't quite sure where that was being applied because that's not what we were experiencing.
Okay, I can answer that too, Piers. It wasn't 8 decibels, 85 decibels at source was for a short period of time in legislation. I don't know when it was, probably in September, where all recorded music and things like TVs and stuff like that in pubs had to be 85 decibels at source, which means you had to put a sound meter literally in front of the speaker. And if it was more than 85 decibels, it was illegal. So we used that for any time that we had recorded music in the, or I don't think we had the television on in there, but recorded music in the marquee. So that was legislation, that was law for a brief period of time, which I'm sure Piers or the legal representative can attest to. And we use that as a rule of thumb. Going forward, obviously, whatever environmental health say and whatever we agree, we will stick to. So it was 85 decibels for, I guess, about 6 weeks when it was legislation that we had to do that.
Right, thank you. So that was applied from what date? Sorry, I
think, Piers, you probably know the dates better than I do. It was when there were so many changes to legislation since July the 4th. But I do keep up with it religiously, working with environmental health, particularly Suzanne Lane, as well as Rebecca. So it would have been those well-published dates as to when legislation was applied. When it came in, and the 85 decibel limit at source was brought in. As I say, we followed it from that date religiously, and we continue to do so for the background music and so on from then. Obviously, that doesn't apply to live music, but what we did do again is we tried to, using the sound meter, I think we used about 100 decibels rule of thumb at the edge of the marquee sort of thing. So, yeah. As for the actual specific dates, you have to look to when the legislation changed.
Thank you. Sorry, just one final clarification on that. I do apologise. In terms of being able to measure that outside, do yourself or Greene King have a mechanism of being able to do that?
Yeah, what I used to do for all the events, apart from the quiz, which obviously I used to do myself, but I didn't honestly realise you could hear it that well. I would go outside with the decibel meter a couple of 3 times in the evening. If I thought it was getting too loud as well, I would take readings outside, and I would take readings inside as well. Currently, we're not under any obligation to make recordings of those kind of things with the meter, but it's possible to do. I just use my common sense. If it was too loud, if it was above 85 dB at source, which it wouldn't really be, because we wouldn't allow it to get that high using the equipment, and we would make a change.
Great, thank you.
Okay, thank you very much. Okay, have a quick scan. Does anyone else have questions for Mr. Scahill and Mr. Warren? Okay, and now I need to ask Mr. Gom and anyone else who who oppose the review of the licence, whether you have questions of fact for Mr. Scahill and Mr. Warren.
No, thank you very much.
Okay, lovely. In which case, I shall turn to members of the panel. So, Councillor Allen first.
Greene King and the Orange Tree, my questioning is around the quiz and the necessity for the language used. I'm a professional quizmaster. That's what I do for a living. Why on earth are you risking offence with people and limiting the number of people that can enter the pub with this attitude? And my second question was around amplification of music. During COVID, I was under the impression that we weren't meant to have any form of amplified music whatsoever.
Okay, I can answer that. Firstly, my quiz isn't, I guess, what you would call a traditional quiz. It's generally an entertainment night. It's generally meant to be fun, and not just me, but members in the audience who are regulars that come participate in the banter, for want of a better term. Now, again, I didn't realise that people could hear it outside. I think the only time we ever got a phone call about it was when an unidentified person asked one of my members of staff to actually give me some abuse. So I didn't really pay much attention to that, although we did immediately turn it down further. So, it's a different type of quiz. And I don't say that necessarily we feel the need to do that. It's something that has evolved. I've been doing that quiz for 10 years. It's an entertainment night. People come out and have some fun. So the fact that I may go on a tangent with negative comments about Donald Trump or whoever who's been getting the brunt of it for the past 18 months, it's not necessary. It's just the way that the evening comes about. And I guess if I'd have known, if is a very easy word to use, I appreciate, but if I'd have known that it was causing offence to people who weren't there, then obviously I've done something about it, because I'm not an idiot. What I also say, just so you're aware, the Orange Tree is a 7-room pub. It's got lots of little small rooms, very old. And when we normally do the quiz, we do it in a separate room, so it doesn't go to the rest of the pub, and people can take it or leave it. If they want to be in the quiz, it's in a closed off room. And honestly, I've never had a complaint about the language from any of my regulars. And believe me, my regulars would tell me if I'd gone too far and becoming less funny and more offensive.
Rob, I'll deal with the second question if I may,
Yeah,
because it's
okay.
a point of law, effectively. When the lockdown stopped in July, on July the 4th, the guidance was issued 4 days beforehand. What the guidance actually said was, if you were to have any live music, it had to be in very, very specific circumstances. And actually, as the guidance has developed over time, there have been different versions of the guidance that relate to live music, which includes grassroots music venues, which is anticipated and expected to include pubs like Rob's, where there is a regular music area. So it's never been illegal to have live music as part of an operation. The guidance set out some very difficult circumstances in which it could happen.
I never said anything about live music. I said amplified music. Live music is fine. Amplified music is what I was asking about.
Amplified music was included. There was no distinction made between unamplified and amplified music beyond the fact, as you've heard, in September, there was this 85 decibel limit set at source, which then was removed again. The guidance has been at times almost impenetrable, it has to be said, and there have been differences of opinion. I sit on committees with the Home Office Institute of License. I sit on their technical licensing panel, and believe me, we had long debates about what was and wasn't allowed. But
I sit on this licensing panel, that's why I was asking the questions.
Yeah, no, absolutely. But what I'm saying is, even from the Home Office down, there have been difficulties in interpreting this.
Okay, thank you very much. We will take / ignore what we can from that. Gerald, do you have any questions for Mr. Scale and Mr. Warren?
Thank you, Chair. Mr. Scarhill first. Obviously, it's within these very, very difficult conditions that we find ourselves in. You've used your initiative and done reasonably well out of it, I hope. Once this is all over and things return to normal, will you continue with live music, entertainment, or whatever outside as you have been doing in the past inside the marquee, or is it your intention that everything reverts back to as it was pre-COVID, Mr. Scarhill?
Okay, couple of points. When you say done reasonably well, we're financially bereft here. I haven't made any money out of it.
Under difficult conditions, I appreciate that.
Yeah, difficult conditions, but also the decisions I made, such as building the marquee, we'll review. This is going to be around for a good year or two, and obviously, as soon as we got to November, they had to close the marquee. So, from a financial perspective, it's been a complete and utter disaster. Regarding what I'd like to do going forward, and I think I've put it in the submission, I would like to do some events outside that are acceptable. So, for instance, the Ballstock Music event, which we primarily do inside, we have done outside on occasion, and some of the other festivals I've asked to do maybe sort of 6 times a year. That's what we'd like to do if it's acceptable to do so. And the Sunday afternoon 4 till 6 sessions, where we've literally got things like an orchestra booked and a choir as well as people with guitars. We would also like, if it's acceptable to do so. But when you look at how we will do these, they are semi-acoustic. You know, I knew pretty early doors that having a full band playing with drums and so on and so forth just wasn't going to be acceptable, and then invested in things like an electronic drum kit and our own back line of speakers so we can control what's happening. So assuming that we can get to a point where everyone's happy, we have the complete ability, and will have the ability to control exclusively the amount of noise, for want of a better word, that comes out. So yes, I would like to, but only on occasions and frequency and noise levels agreed with our neighbours.
And the marquee?
And in the marquee, yes. I don't think we'll ever do anything in the garden, because I think in the marquee, which is now fully enclosed, we have got, as we learnt, is a much better way for us to control the noise that escapes. And there is still more that we can do in that marquee, and we will work with environmental health on what are the best ways to approach reducing that sound even further, whether it's using noise baffling. And we do also already have the control devices in, just a question of setting them.
Thank you. Mr. Warren, within your proposed conditions, you mention records of checks being taken at the start of each live recording music event. If we do consider your proposal, would it not be more appropriate to have a fixed noise meter? Because obviously the volume could go up. I mean, you'll check it at the start, and then it could obviously go up later. So might it be an idea to have it permanently? And my next question is your last bullet, no more than 2 live music events, excluding background music. Do you mean there will also be background music when there are not live music events, or there won't be any background music in the marquee? This is.
Piers, can I answer the first one? We already have limiting devices in place. I've showed them to Environmental Health. They now need to be set. So the process that we were going to go through with Rebecca from November was to agree what those levels were. It will take us, we have to run some live events, obviously, but those things are already in place and just require the level setting to them.
And they would be throughout the period of any entertainment, presumably.
They would be forever, because obviously just by the well, I think once you set these things up, they're locked.
And my thing about background music is background music when there's not live music, or is there no background music? Is that what's proposed?
We currently play background music, yes.
In the marquee?
Yes.
So background music by its nature is not licensable. So it falls outside of regulated entertainment in any event.
But it could be, okay, but it could be as noisy as live music.
Well, if it is that loud, that becomes recorded music.
Okay.
Technically. So actually recorded music, live and recorded music events are included in that condition.
Okay,
just to explain, the reason I drafted it that way is because there are changes in wind conditions and things like that. It's always better to do checks outside as well as having a limiter inside. So you set the limiter and then you do checks outside to make sure you don't need to make any corrections.
And lastly, Mr. Warren, should you have perhaps included a suggestion around Mr. Scarhill's interesting vocabulary? Would that be appropriate? I think it is quite relevant, really.
No, it's not, Gerald. That's a personal matter, and I think Mr. Scarhill has heard enough from residents and is mature enough to understand how to use his words.
Chair, foul language, if that's what we're talking about, it's not appropriate.
No, it's not. It's absolutely
it's not
licensed.
licensable
Mr. Scarhill
either,
knows
Gerald.
better. It's not licensed, and I'm certain that he will control himself at
Certainly
future
hope
quizzes.
so. Thank you.
I can go and say something. I'm going to guarantee to you that, listen, the language that I use during the quiz, it's the only time I even permit that sort of language in my pub, will only be done when the quiz is done inside in that closed, confined space with people that are happy to be there. And believe me, I can read an audience. I've been doing this for a long, long time. So I know if I'm offending people, if I can see their faces and see their responses. It's very difficult to know you're offending people when nobody tells you.
Oh, I give you a get out of jail free card and you just threw it away. All right, Councillor Morris does not need to come back on that. I do not have any questions for either Mr. Scarhill or Mr. Warren. Do Councillor Allen or Councillor Morris have anything else that's relevant to public nuisance as opposed to language?
No.
No?
One more quick question, sorry.
Yes.
The sound limiter, you said that you've got a sound measurement. The sound limiter that is in the marquee, what is it and what is it set to? What is the limiter?
Okay, it's a compressor. Now, what that does is that records, monitors the sound that comes out of the deck before it gets to the speakers. And what you can do is you can configure that so that it doesn't put out a noise level above a particular setting. At the moment, it's not turned on. It just literally sits there because, as I said, the plan was to work with the council on agreeing what it should be set to. So it's a proactive device which proactively monitors all the music going into the speakers in the marquees. That's from the television, the background music, the microphone, should we use it for anything. So it's there and it's ready to go, but it's not set.
Speaking as a DJ and quizmaster, can I just double check that can't be got around by plugging the power in through a different outlet?
Yeah, I mean, you can get around most things, as you well know, but what would that achieve? I mean, why put a sound limiter into the pub in 2012 as a result of our first approach to the licensing committee? And those things are positive things. They help you. The last thing I need or want is to go through all this process of putting all this stuff in. It's not cheap, as you well know, for then to try and bypass it to get me into more trouble. It simply isn't worth it.
Fantastic. Thank you so much.
Okay, all right. So if there are no further questions, that concludes the main submissions from everyone. The next phase in proceedings would be to move on to closing statements. Before we do that, I'm aware that we've been going for 2 hours now. So if we would like to take a 5-minute comfort break, and that will obviously help everyone prepare a little bit for those closing statements. And then we'll come back after that and wrap things up. Can I have some officer assistance to make that happen, please?
Thank you, Chair. Matthew will put up the holding screen, and could everybody make sure they've got their microphones and cameras turned off, and we'll reconvene at 12:10. Thank you.
Thank you very much, everyone.
Could everyone turn their cameras back on so we know you've come back, please? Thank you.
We've also got a person that's joined with the iPhone. If you could unmute yourself and show your camera and rename yourself, please.
It's Mr. Marison again.
It is, yeah, sorry.
Okay, I'll just rename you.
Thank you.
Thank you.
Chair, it looks like we have, I think, everybody back. Would you like me to do the roll call?
Yes, if we could, please, Anna. Yeah.
Sure. So panel, we have Councillor Dennis Harburg.
Yep.
Councillor Daniel Allen. Can't hear you, Councillor Allen. I can see you. Looks like you're on mute. At the
Hello.
moment.
Yes, I'm here.
Okay, thank you. Councillor Gerald Morris.
That's me, yep, thank you.
And Councillor Ian Albert.
Yep.
And officers, Steve Cobb.
I'm here.
Jasmine Jennings.
Yep, yep.
Teresa Campion.
I'm here.
Matthew Hepburn.
Yes, present.
Thank you. And Rob Scahill.
Yep.
Piers Warren.
Sorry, yes, I'm here.
Andy Turner. Thank you. Fred Miller.
Yes, I'm here.
And Margaret Miller.
Yes, me too.
Lee Garnish.
Yeah, I'm here.
Chris Gom. Come back to him in a moment. I think he's disappeared. Paul Hooton.
Yes, I'm back.
Chris Bentley. Not sure we can hear him. Michael Camp.
Yes, I'm here.
Andrew Marison.
Yes, I'm back.
Jane O'Brien.
Yes, I'm here.
And Liz Smith.
Yes, here as well.
And so Phil and Kate Corney.
Yes.
Is there anybody I've missed? Okay, thank you, Chair.
Okay, excellent. Thank you very much. Okay, so we've now heard all of the submissions from both the applicant for the review of this licence, the other persons for both sides, and the respondent. And so the last thing for me to do is to move us to the closing statements. So there's going to be no opportunity to ask questions. This is the final word, your final summing up effectively of your case to the committee before we go away to consider our decision for today. So if I could first ask our licensing officer to make final submissions for the committee. I think, is that going to be Steve Cobb again?
It will be me. Thank you. I'll do the best to make some sense out of the notes I've been scribbling during the hearing. But it seems, in my opinion, that this hearing revolves predominantly around the effect of the deregulation of live and recorded music. And just to reiterate, so people can either address it in their closing submissions or the councillors can have regard to it, just remind everybody that the existing conditions on the licence will not apply going forward. If the councillors wanted to apply them, they could put the caveat on that I mentioned before about section 177A not applying to individual conditions rather than removing everything carte blanche. And I think that ethos has been very helpful in the conditions put forward by Mr. Warren on behalf of Greene King, addressing the main issues during the COVID restrictions, with those conditions then falling away, because those two conditions can have the caveat of being 177A disapplied, and so they will have effect, whereas the others won't. I know that's probably confused everybody even more, but
what I'm trying to explain is it's a sensible solution to the problems before us in terms of way to address it. I'm not necessarily suggesting it's the decision that the committee should make. Also, in restriction to those conditions, just 2 points of comment really. Whilst Mr. Scarhill has said that he has no intention of having any quizzes outdoors again, and this is a licensing hearing, it is an offence to give false information. I just have to make that clear. I don't expect anybody would lie in a hearing, but the conditions as worded by Mr. Warren would of course allow 1 quiz a week to take place. So if there is no intention of having that quiz, it might be useful for that condition to be amended by the premises licence holder. Also, it restricts live and recorded music for 2 sessions a week outdoors. Again, once that falls away at the end of COVID, technically live music or recorded music could take place outdoors every day of the week. Again, it's been said that that's not going to happen, and I don't know whether the applicant would like. I'm not suggesting it is the way forward, but given the move to try and everybody work together to put some restriction on outdoor entertainment in terms of numbers per year going forward post-COVID to reassure the residents that the current situation won't continue. In terms of language, as the chair said quite rightly, foul language is not a licensable activity. However, foul language on a licensed premises would fall within the remit of protection from children from harm if children are hearing it. And I believe some people did say that children were hearing it. And so it's something that the committee can consider, but in that very narrow remit of the impact on children, not the impact on adults. That clearly wouldn't be covered by the Licensing Act. And ultimately, the subcommittee are making a decision on public nuisance. As our policy says, it's the council's intention to strike a balance over what is reasonable and what is not reasonable. I don't think society has ever existed where there has been no nuisance, but what the subcommittee are trying to achieve is what do they think is reasonable in terms of the people living around the premises. In terms of the committee's decision today, there is a right of appeal to all parties to the hearing. That right of appeal would be to Stevenage Magistrates Court within 21 days of receiving the written decision notice. As this is a review hearing, any decision that the subcommittee take today wouldn't take effect until the end of that 21-day period when a review could be lodged, or if an appeal is lodged, until the appeal is disposed. And finally, as with all licenses, there is an opportunity to review a license at any time. However, a word of caution for the other persons is that in terms of requesting a review, the licensing authority do have to consider whether a request is repetitious. That's designed so that the same review on the same grounds can't be lodged over and over and over again until the desired outcome is taken. I'm not saying you can't review this license again on the grounds of public nuisance. What I'm saying is, in order for a further review to be accepted on public nuisance, we would need to see evidence of evidence going forward from today. Effectively, you've raised your concerns that have taken place over the period of the COVID restrictions, and the subcommittee will deal with them today in whatever way they feel is appropriate. Going forward, wouldn't expect another review to arise on what has happened so far. The review would have to reflect what's happened since the committee have made their decision. I hope I haven't confused too many people and that's helpful, Chair.
No, thank you very much for that, Steve. Okay, so I now need to ask for the other persons, the other persons supporting the review to make their final submissions to the subcommittee, if any of you wish to do so. After I've heard from you, then I will take Mr. Miller's final submissions. So, anyone excluding Mr. Miller Mrs. Miller.
Sorry, I forget to turn my microphone on. I suppose I would be looking for some reassurance that these proposals in the plan will be secured by law or some sort of form of decision by the council. I mean, I cannot understand the sudden change in the attitude that we are experiencing this morning when at the end of lockdown, when the pub was open again, on the microphone it was announced that our neighbours have had it quiet for far too long. Let's make some noise and wake them up. That does not seem to be the same sort of attitude that we are listening to this morning. And I suppose really it's us having to trust the publican with a lot of, with enforcing quite a lot of things that we have heard about today. And I can't say that I'm overly confident that they're going to be adhered to in the manner in which they will be presented. Well, I just cross my fingers that the change of mood and as it seems to be today, that it will continue into the future. There are a couple of things that struck me when reading about the new plan. In fact, there are a lot of things that struck me when reading about the new plan that is there. We're talking about music and noise nuisance and whatever. How is the clapping, whooping, cheering, whistling and backchat to be monitored? This is all that we've experienced in the last several months. How is that going to be handled? That is as intrusive as anything else that we have heard. They are quite noisy gatherings without even taking into account the music. There are several things really. How I've got here, are we being asked to believe that a busy landlord is to hold his decibel meter in his hand to decide on noise levels and do a tour of the local residents' properties with a full pub and waiting customers? I mean, it just seems an impossible task. I've got here, even a conscientious landlord might well find it difficult to keep up if the pub is closed, if the pub is full, I mean. So what guarantees are we going to have that the landlord is actually going to stick to the rules that are going to be imposed on him with this new plan? I think that's about it. I mean, I have a lot of paperwork here, which I haven't felt that I've been able to include in my contribution, but that is the main thing that's coming up. How are we going to be assured that what is proposed is going to be adhered to?
Okay, thank you very much, Mrs. Miller. Do any of the other persons supporting the review wish to make closing submissions? I can see I got Mr. Garnish first. Mr. Gorm, I need to take you after Mr. Miller because I believe that you're against the review of the licence. And I shall take Mr. Kemp after Mr. Garnish. Okay, so Mr. Garnish first, please.
Yeah, just an observation with the noise monitoring equipment. Obviously, at the moment in the pub, it's inside a proper building. We're dealing with a 5mm thick nylon marquee, and I just fear that this music, whatever, even at the you know, it's just going to be way too loud. I don't know how that building contains music. So going forward, that is a big concern, because in the pub, you literally can't hear it. But in the garden, I don't see how it's going to work with nothing more than a marquee and a little bit of wood. So that's my concern. That's it, really.
Okay, thank you very much. Mr. Camp.
From what Mr. Scarhill was saying, he seems to be intimating more events perhaps than the solicitor representing him was suggesting. That's one point. But my question, or my observation for the panel really is that location suitable to house outdoor music events when it's surrounded in close proximity by over 40 houses, all within 150 metres of it? And however limited the music may be, which may not be to the musicians' liking themselves, if the clapping and the enthusiasm and the noise of those attending adds to that noise, however can that be controlled? And that's, I repeat the question, is this location, a confined garden in close proximity to so many houses, a suitable place for outside musical entertainment? That's it, thank you.
Okay, thank you. Okay, so before I move to hear from, I think the next person I need to hear from is Mr. Miller. Does anybody else supporting his application wish to make final submissions? Okay, so Mr. Miller's is going to be the final submission that we hear in support of this review, unless anyone indicates now that they wish to add. No? Okay. Yes, there we go. Mr. Corney.
Thank you. There were a few statements on being able to understand or sort of read the audience and understand what's being expressed by the neighbours. And I'm not sure how the proposed conditions that are being applied here will improve that, as that's what has been happening to date. And there has been outside measurement to date. So I suppose my support of what Maggie's been saying there around how should this be enforced is a really important concern for us, particularly with young children and having another hot summer, hopefully, and then also beyond when the COVID restrictions will be lifted, and how can we get that to best work for both parties.
Okay, thank you very much for that. Okay, so, and to wrap things up now for the case for reviewing this application, could I please hear from Mr. Miller, your closing submissions, please?
Hello. I'm very disappointed that the environmental health people were not involved with this meeting, because a lot of our case revolved around their findings. Mr. Cobb, I think, put his finger right on the subject matter. It is what is reasonable and it is what is unreasonable. And what we have had to put up with the latter half of 2020 has been very, very unreasonable. I've heard my age, I think, comes into this. I've heard a very, very lot of technical detail about the law, and one thing and another. It's just gone on and on and on. But again, it's what is reasonable and it's what is unreasonable. And I cannot believe that things have been allowed to proceed as they have done. It's been absolutely mind-boggling, and also very educational listening to what's been happening this morning. All I can do is ask the panel to remove the deregulation. That would be, for me, the very, very best alternative. If they don't do that, I would like some quite strict restrictions to be placed on the license of how they're going to proceed. Thank you.
Excellent, thank you very much for that. Okay, so if I could then ask the other persons who oppose the review, so that would be Mr. Gom and any others who support the orange tree and not the licensing review, to make their closing submissions.
You just need to unmute your microphone, Mr. Gom.
That's it.
Okay, sorry. Apologies
There we
for
go,
that.
we can hear you.
Seems to be quite a delay. I'd just like to say I think it's a shame that Environmental Health have not been able to finish their work with the pub, because it seems to me a lot of the issues have been identified and are in the progress of being resolved, but clearly they need to complete their work, and then maybe this wouldn't have come to this point. And also it seems to me that communication between the residents and the landlord have not been brilliant, and perhaps in future the residents could communicate directly with the landlord so he's aware of what is going on in the vicinity and can deal with the issues. I know you're nodding your head, Mrs. Miller, but clearly the man, he's a responsible man, and he will respond to you as he does to everybody he talks to in a responsible way and mitigate the issues. If he doesn't know, then he doesn't have the chance to do that. And lastly, I'd just like to thank the chair for running a very good meeting, because this could have been a complete fiasco, but it hasn't been. It's been very well run, so thank you.
Oh, thank you very much. Flattery gets nobody anywhere in my meetings, I'm sure officers will tell you. Okay, so if I could then ask for the premises licence holder and or representatives to make their final submissions to the subcommittee. I'll let Mr. Warne and Mr. Scahill decide which way round they want to do things.
Thank you. But that's my summary written down out the window if I'm not allowed to use flattery. All gone. No, look, on a very serious note, we've listened hard to what's been said. We would say, obviously, that had this been resolved earlier, I think it would have been to everyone's advantage, but we are where we are, and this is the perfect forum to try and come to a balanced and reasonable decision. And that's what we're looking at, is balance here. I would say on a technical note, so again, for Mr. Miller's learning, albeit it's probably technical mumbo jumbo he doesn't want to hear, if you are to remove the section 177A exemption across the board, you would have to have evidence of public nuisance prior to COVID for it to affect all of those things, I would submit, inside and out. But obviously the submission I've made, and you've heard from your officer, has been to try and divide this into what's at stake here in terms of what are the issues in front of you, which are all COVID relate, all stem from the COVID crisis, and the operation before, which no one has said caused any kind of issues at all. That includes, it must be remembered, events that have been held in the garden, such as the small festivals. They're regular features at many pubs and venues. They come with advance notice. They're fairly infrequent, and obviously they're very important to the community. So I'd ask you to be very mindful in any conditions you impose in not accidentally restricting those kind of activities by imposing conditions that would do so. We put forward a number of conditions, and you are asked as a committee to assess effectively the risk and benefits. That's the language that the guidance uses it. I think it's paragraph 9.44 as to how you make your decision. So what are the risks and benefits? Well, the benefits we've heard all about, and we've heard from residents who have said that these are quite important events for them. It's recognised in your own policy that is the case. The risks are of causing a public nuisance, which is different from a disturbance or a noise nuisance to an individual, and it's a very difficult line to tread, and it's never been easy. But we are talking about public nuisance here. And there is some mixed responses. I'd remind you of that from residents who live very close by as to what is and is not a public nuisance here. There is a desire for the pub to succeed by all parties, which is really good to hear. And indeed, we have to recognise we're in a 100, 1 in 100 year scenario. and Rob does have a genuine desire to fix matters. So in terms of the conditions then, let's start with the final condition. We would remove the quiz from the bottom condition, so no more than 2 live music events, etc. Remove the quiz from that as a spoken word event. If you feel that's appropriate, Mr. Scahill has said he has no intention of hosting the quiz outside. So that's something that you should take into account, and it prevents any kind of discussion really about that. In terms of the other conditions, I would say that they are appropriate and proportionate to these events. Mrs. Miller made the point, well, it's very difficult for Mr. Scahill to do checks, run the bar, manage his team, serve food, etc. Well, the reality is of the condition about the checks he has to do and the management plan he has to draw up is that if you impose them as a condition, they must be done. Ordinarily, he has a significant number of staff. You've heard 18 staff. All people have different jobs, and it's something that must be done. So if you impose that, that's the obligation on him to work out how to do it. In terms of any other conditions, obviously you could add, Mr. Scahill does have a limiter in the outside marquee. So you could impose a condition on the limiter in the marquee, for instance. I think that's Mr. Gom's dog. I can hear there. Yes, so you could impose a condition there. I would consider very carefully whether you need to impose any other permanent conditions outside, as I say, because one ends up then going into the territory of affecting things that were going on before COVID, which aren't in dispute here, as I say, such as little festivals. But if you were to look at the number of events, you've heard what Mr. Scahill said, and it didn't contradict what I was saying. You know, he talked about 6 events, you know, externally a year with a short 2-hour Sunday session. In addition to that, if it was workable, and then moving everything else back inside when COVID allows for it. But as I say, I'd caution against those kind of conditions because they do tend to restrict things unnecessarily if you've got the other measures in place anyway. That really is all I have to say. Thank you all for your time. And if the residents take anything away from this, we have listened very closely, and Greene King will work with Rob. And if there are any complaints that come to Rob or Greene King directly, we will act. We will work with them on this. Thank you.
Okay, thank you. Is Mr. Scahill going to be also making closing submissions?
Only just to say thanks for this opportunity to look at everything again, and I take everything positively. So I hope that when the committee look at what we're going to do, that you've got something or give me something I can work very closely with. And that's it, really. So thanks for everything.
Thank you very much. Now, my next step would be to move for and ask our legal advisor for information submission and guidance before the committee retires. I can see Gerald's waving his hand in the air, and I also heard something in Mr. Warren's closing submissions that I think we need clarifying. Looking at the conditions, and in particular the one around entertainment out of doors, I can't see a simple form of words as drafted that would unambiguously exclude quizzes outdoors. Now, if it is indeed the intent that quizzes will not be taking place, do you have a form of words that you can give this committee before we go away to consider our decision that would sort of solidify that commitment?
I agree. It's very, very difficult, isn't it, actually? But yeah, removing the no more than one spoken word event was effectively my attempt at that. But you could add a wording that effectively said there will be no quiz held in the external area or marquee during the COVID crisis. Well, you don't need to say the COVID bit, do you? So.
No, I think I would be more comfortable with something saying quiz, because obviously a spoken word event is more than just a quiz. It would exclude things like beat poetry, plays, etc., etc. Obviously, I'm not going to impose a condition myself. It needs to be something that comes from yourself and Mr. Scahill. So if you want to amend that before we go away and consider, or alternatively leave it as is and see what we do with it.
I love the idea of spoken word and beat poetry. Reminds me of my studies. I don't know how often Rob has those, but if you wanted to leave the wording as is on the second bullet condition and then just add a specific condition that said there will be no quizzes held in the external areas or marquee, I think Rob's nodding his head and Andy's nodding his head. I think we would accept that.
Okay, bear with me. I might have to yell at a small dog because there's a cat. Okay, hang on 2 seconds. I've got something to say on this. There we go. That's a minor improvement. Okay, so I can see Rob nodding his head and you're jotting down a form of words. If we can have that recorded by officers and accept that as a third bullet point on these conditions, are those of us that are able to agree and be happy with this happy with it? I'm looking at Rob and Piers primarily. Yes.
Of course. Yeah.
Okay, perfect. Thank you very much for that then.
Sorry, I was just going to say for clarification, that's the third bullet on the conditions that relate to COVID, just for clarity.
Yes,
okay.
That's where it sort of appears in its initial form, isn't it?
Thank you.
Okay, and then if I could then move to the legal advice, please. So I'll invite Teresa Campion to present.
Sarah, I had a question, can I?
Technically no, but I feel generous. Go on.
That's very kind of you. Thank you. So just clarifying post-COVID, are we saying, Mr. Scarhill, that you would revert back to perhaps six live music events outside throughout a year and no quizzes or similar? Is that what you're saying, post-COVID?
I'll respond to that, Councillor, if I may. Yes, so what he said in his submissions and what we're saying here is he's going to revert back ostensibly to what was happening before, but he would like the opportunity to have the 6 events or so outside per annum, but also the 2-hour Sunday session, which is the semi-acoustic session that runs from 4 to 6. So a 2-hour session, if you like, on Sunday afternoons as well, to have the ability, if it worked, to have that in the marquee.
And no quizzes or similar?
Rob, you've got no intention of having the quiz outside again, I take it?
No, never.
Post-COVID, yeah?
Ever.
Okay. Thank you, that's all.
All right, thank you for the clarification. Okay, so I think third time of trying, I'm going to move to legal advice from Teresa Campion, please.
Yes, there are a number of powers that are available, options available for the committee in making this review application. Firstly, there is an option to take no action. The second option is being discussed quite widely in relation to either modifying the conditions of the premises licence and adding new conditions, or altering or omitting existing conditions. And the other particular issue I understand from this application is regarding the live and recorded music outside. And that's been discussed by both the legal advisor for Greene King and the licensing manager. Have to consider section 177A of the Licensing Act 2003 and actually say that doesn't just disapply, that otherwise the pub can actually hold music as of right without a license between 8 AM and 11 PM. So in order to impose any additional license conditions in relation to that, you would have to say that section 177A of the Licensing Act 2003 doesn't apply. And I think that included any proposals put forward by conditions put forward by the applicant, as well as conditions that the licensing committee may think appropriate. You can exclude a licensing activity, but I don't think this is relevant in this particular case. You can remove a DPS, you can suspend a license or revoke the license, but the main issue seems to be in this case regarding the outside area. Some members may want to consider the imposition of additional license conditions if they feel it appropriate, and removal and deregulation, making the Music Act 2012 not apply to this premises in relation to the outside area. Whatever conditions you impose, if you choose to impose any conditions, they must be reasonable and proportionate and enforceable. And this is a right to appeal to the Magistrates' Court by all parties. There has been reference to environmental health, but there is an open investigation regarding this. So any information going into detail regarding that has to be treated with some caution, as there has been no representations from any of the responsible authorities. In this case, the relevant responsible authority would be environmental health. Unless I can assist you any further, that's advice. There is the option, I think, for a further review if of the premises license, should the license be additional conditions being put forward. There is a right to a further review, but obviously it can't be on exactly the same matters. There would have to be new information put forward to support any further review of the license. So unless I can assist you any further, that's all I need to say, I think, at this stage.
Okay, thank you very much, Teresa. Okay, so members of the panel, do you have any legal questions for our legal advisor before we retire?
No.
No, Chair.
No.
No. Excellent. Okay, in which case then, ladies and gentlemen, myself and Councillors Morris and Allen are going to retire to consider everything that we've heard today and reach a decision about this particular application for review. I can't say how long this is going to take. We'll be doing it in a separate Zoom breakout room, and I think the YouTube channel will also be displaying a blank screen during this period of time. So if you want to take the opportunity to rest, recover from this morning's meeting, have some lunch, etc., I would strongly suggest doing that. Those of you who would like to be in the room or need to be in the room to hear the decision, I think officers will notify when we're about to come back. I wish to thank you very much for your contributions and patience and good work today. Have a great lunchtime, and I'll see those of you later on who I see.
Chair, do you need me as well?
Officers, can I have some advice?
Yes, please. Yes. Before you move to the breakout room, Chair, if members believe that the decision will take too long to avoid parties waiting, they may decide to announce the decision, not to announce the decision live today. If this is the case, an announcement will be made to this effect by the subcommittee and the meeting will be closed. The decision would then be announced in writing within 5 working days of the meeting. Okay, so Matthew, if you could open the breakout room for the panel and legal advisor, and if everyone else would like to mute their microphones and turn their cameras off, and they're quite welcome to stay and wait for the decision. Thank you.
All right, all right.
Anna, do you need to do any kind of introduction-y thing?
There's nothing for me to say apart from just to let anyone know who's just listening that we are about to announce the result. So if you haven't turned your camera on yet, or you're away from your computer, we're back now. I think everyone's probably back who's here.
All right then. In which case, thank you very much, everyone, for waiting around on a Wednesday when I'm sure you've all got better places to be. Wait, no, we don't. And having the patience while we considered the decision that we've reached in this particular licensing review. So I'm going to read through the decision sheet. It's going to be hopefully not too long. It might be slightly dry in places because I have to refer to relevant sections of licensing policy, etc. So please bear with me. So this is a decision of the North Herts District Council Licensing Subcommittee of the 6th of January 2021. Members of the panel were Councillors Daniel Allen, Elizabeth Dennis Harburg and Gerald Morris. Considering a premises licence held in the name of, on my sheet here, Rob Scahill, I'm aware obviously Green King looks after the pub as well and is the official licence holder. The premise address is the Orange Tree Public House, Norton Road, Baldock, SG7 5AW, and we received the application for review on the 20th of November 2020. This is an application for a review of a premises licence under Section 51 of the Licensing Act 2003. The subcommittee has read the material presented to it and has listened to all the evidence and submissions. The subcommittee has considered the national guidance and the statement of licensing policy and has come to the following decision. The subcommittee has decided to modify the conditions of the premises licence as follows. Section 177A of the Licensing Act 2003 does not apply to this condition to live music and recorded music. I believe we had discussion around this during the hearing. The conditions deemed appropriate for the promotion of the licensing objectives. So the subcommittee recognises that conditions will only be imposed on a licence where conditions are appropriate for the promotion of one of the 4 licensing objectives. The subcommittee will only impose conditions on a licence where relevant representations have been made and it considers that it is appropriate to impose conditions as a result of these representations. The following conditions are each considered appropriate by the subcommittee to promote the licensing objective of public nuisance. The conditions are: 1. There shall be no more than 6 events, parentheses, conditioned to apply after any period of COVID-19 restrictions affecting the premises has ended and normal trading has commenced under the Licensing Act 2003, and of live music or recorded music sessions in the outside area. Section 177A of the Licensing Act 2003 obviously does not apply to this condition. 2. The installed sound limiter needs to be commissioned and agreed with North Herts District Council Environmental Health or Environmental Protection prior to any outside events taking place. Again, obviously, Section 177A of the Licensing Act 2003 does not apply. There's been no representations and no conditions imposed or recommended by responsible authorities. Conditions proposed by the applicant. The conditions are to be permanently applied as set out and submitted by Mr. Warren on behalf of Mr. Scahill are accepted, with the addition of a third point, which is there will be no quizzes undertaken in the outside area or marquee, as discussed during the hearing. And again, the conditions that apply during any period of COVID-19 restrictions, which were submitted by Mr. Warren on behalf of Mr. Scahill, are accepted, with the confirmation that Section 177A of the Licensing Act 2003 doesn't apply to each 1 and 2. And again, the addition of a number 3, which is there will be no quizzes undertaken in the outside area of the marquee, as discussed and agreed during the hearing. The effect of failing to comply with the conditions needs to be explained to the applicant, although I'm sure he's very aware of this. If you don't comply with any of the conditions attached to the licence or certificate, it's a criminal offence for which you can face upon conviction an unlimited fine or up to 6 months imprisonment or both. One condition that this authority cannot impose, of course, is in relation to language used at the premises, during events, etc., and which might be overheard. However, I'm certain that a responsible publican will be aware of the distress that hearing certain forms of language might cause to neighbours of all ages and sensibilities, and I would expect the publican to act appropriately. Statutory guidance. The subcommittee has taken into account the guidance issued under Section 182 of the Licensing Act 2003, as amended in April 2017. In reaching its decision, it has found that a number of sections are relevant to its decision. I am not going to read out the list of section numbers I have, but they will be in the decision notice, which will be published. Licensing policy considerations. The subcommittee has taken into account North Herts District Council's statement of licensing policy in reaching its decision. And we found that, again, a number of sections of our own licensing policy are relevant. I'm not going to read out the list of letters and numbers that form those sections. They're in the decision notice for reference. The reasons that we've reached this decision, the subcommittee felt it was apparent from, excuse my email, the subcommittee felt it was apparent from the representations that unregulated music outside of the premises was causing a nuisance to residents, and it was therefore appropriate to remove the deregulation of music contained within Section 177A of the Licensing Act 2003. Secondly, in including the aforementioned conditions, so agreeing to those proposed by the applicant and also the additional points that we felt were appropriate to add on to the licence, the subcommittee was confident that the conditions were an appropriate and proportionate response to address the causes of concern which instigated this particular review. This decision will come into effect from the end of the period for appealing the decision, or if the decision is appealed, the point at which the appeal has been dealt with by the Magistrates' Court. Rights of review. Should any of the applicants be unhappy with this particular decision notice at any stage following the grant of a premises licence, a responsible authority such as the police or any other person such as a resident living in the vicinity may ask the licensing authority to review the licence because of a matter arising at the premises in connection with any of the 4 licensing objectives. The review is a request for the council to look at the existing licence and decide whether its conditions are adequate to meet the 4 licensing objectives defined under the Licensing Act 2003. This application for review considered by this subcommittee does not preclude parties from applying for a further review. Obviously, as the licensing officer has said, it has to be on future events. We cannot revisit the exact circumstances that we've looked at today. All right, and that concludes our decision notice. It will be published and available and distributed, I think, by officers. I don't want to give them a deadline because I'm not sure what their work burdens are like, but I think that is the end of our business for today. Thank you very much, everybody, for your positive contributions and for taking the time to be with us. And I wish you well and hopefully have a very happy new year.
Thank you, Chair. I hope everyone stays safe.